Welcome to guests. I call the meeting of the Texas Real Estate Commission to order at 10:03 a.m., February the 11th, 2019, and to ask everyone to please stand while Commissioner Westcott offers the pledge.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Honor the Texas flag. I pledge allegiance to thee, Texas, one state under God, one and indivisible.
Thank you. You may be seated. A couple of housekeeping. If you intend to speak on an agenda item, please fill out one of these forms at the back and hand it to Amber. Wave so they know who you are. So this form to speak. If you're here for credit as a real estate license holder for attending this meeting, you need to stay through the end of agenda item 19. So if you leave before 19, you're not getting any partial credit. Did I say that right, General Counsel? Okay, good. Thank you. I seek a motion to excuse the absence of Commissioner Turner.
I so move.
Second.
All in favor say aye. Aye. And opposed, no. Motion carries. It's that time of year, every year, when we have the opportunity to elect a vice chair and a secretary for the commission. So I would open the floor for nominations for a vice chair.
I nominate Bob Leonard for vice chair.
Okay, I have a nomination for Bob Leonard. Is there any other?
Madam Chair, is it out of order if I ask a process question?
Perfectly fine.
I have a question regarding, we have an opening for vice chair and secretary. And since I think for continuity's sake, that whomever we select for vice chair, that perhaps we have a secretary and the role automatically move up in case there should be a vacancy in the vice chairmanship.
So if the vice chair were unable, for some reason, that the secretary treasurer would automatically move up to vice chair, and then you would elect the treasurer. Can that be done at this time, or is that something that we need to talk about at agenda item, whatever it is, tomorrow, 26 or something, on procedure? General Counsel, no microphone.
Get my mic, there you go. Yeah, that's a policy issue, and you can certainly make that policy. You need a motion to do it, and I think that really is more appropriate when we talk about commission committee appointments under 29.
Is it okay if we do that on 29?
Yeah, so we'll just remember to do that.
Is that all right with everyone to have that discussion at the time? Okay, I have a motion, I have a candidate, only one so far, for vice chairman. Is there anyone?
Yes, ma'am.
Yes?
Madam Chair, I'd like to nominate Commissioner Arriaga
Okay. Is there?
for vice chair.
Thank you. So we have two nominees for vice chair.
I would like to ask, if appropriate, if Mr. Leonard is willing to serve,
Oh,
one.
that's a good question.
And secondly, for continuity's sake, again, with us losing, per the term limits, Commissioner Arriaga and you as chair, perhaps, we maybe have discussion on that before we vote.
Madam Chair?
Yes, sir.
I would like to serve the remainder of my term, and I understand correctly, the appointments director mentioned that the people rolling off, which is 3 of us, are going to stay hopefully through the session because of the continuity that they have. And at that point in time, if I get selected, which I want to serve, you can replace me or vote for Mr. Turner, for Mr. Leonard.
Okay. Okay.
Thank you.
Thank you. I guess we'll vote. What? I'm sorry.
So possibly for more clarification.
Yep.
But we don't have anything in place until item 29. We could vote for Mr. Leonard as secretary. And or would a secretary be part of the executive committee, and is that a whole?
Secretary is a part of the executive committee, and
So that could all work.
it could work, or we could do what we have often done, which is vote, let people vote, and right now, and see who wins. a good way to do it, yeah.
The short answer to your question, Commissioner Wilkinson, is yes.
Okay. So you're willing to serve, and Mr. Arriaga is willing to serve. Okay, so.
Well, can I make an amendment then to our motion, since we don't have that coming up to 29, that I would like to nominate our present vice chair, for vice chair, Adrian, and then to have a secretary that would automatically move up, Mr. Leonard.
We would have to vote on each position. You can't, people haven't voted who is, that can be your motion, but you can't have him automatically move up. So we're doing the vice chair voting, and then we'll do the secretary voting.
Yeah.
And they'll be in place, and then we can certainly address that other motion or do 29, and any other issues surrounding election of vice chair and chair. I mean, and
My point is trying to have continuity.
right. Now, remember, there is currently, for continuity, there is currently one member on the executive committee, and that he is not here, but Commissioner Turner is currently the secretary and has served in that role, and his term is not expiring. So one important thing to think about with continuity is to have somebody who is currently there, who we know is not leaving, be in one of those positions. And that's just, if that's the best way to have continuity.
What, excuse me?
As
Uh,
are you,
Yes,
speaking of continuity.
I will be the absence of continuity, because I'm going to be replaced
Right. 2 out of the 3 executive committee members
currently.
currently will roll off sometime whenever the governor reappoints, because remember, they serve until reappointed. So,
Okay, so,
Madam Chair?
Yes.
If I may, also, that when the time comes to, if anybody moves, or anybody has served their term, that there's a possibility to vote again and re-elect
Yeah, yeah.
whoever that is, instead of selecting them at this time, because at that point, there will be new commissioners.
that's right.
Thank you.
You're correct. You will be doing it so again this year sometime, likely. I mean, I don't know that, depends, because the governor will appoint a chairman. That's how that works. So, we have 2 candidates for vice chairman, as I see it, and so we're going to have, each person will have 1 vote. So, let's, Commissioner Leonard was put forth first, so I would like to see a show of hands for Mr. Leonard. Leonard, Westcott, Miller, and Wilkerson. And a show of hands for Mr. Arriaga. 3. So it looks like, Mr. Leonard, you'll be serving as vice chairman. So now I would seek nominations for secretary treasurer.
I would like to nominate Commissioner Arriaga.
Okay? Are there any other nominations?
I'd like to nominate T.J. Turner, Commissioner Turner.
Okay. Commissioner Turner, Commissioner Arriaga. Okay, let me see is there any discussion on any of that? Or did we discuss enough? Okay. So, all who would vote for Commissioner Arriaga for Secretary Treasurer, let me see your show of hands. Okay. That, and Commissioner Turner. So that's Commissioner Arriaga. So it's Commissioner Leonard as Vice Chairman, Commissioner Arriaga as Secretary Treasurer. That took a while, and thank you for doing that. Our next item on our agenda are appointments to committees. For the 2019, for the Enforcement Committee, we'll have Commissioners Leonard, Turner, and Westcott. For the Budget Committee, we will have Commissioners Arriaga, Stevens, and Williams. For the Long-Term Facilities Working Group, Commissioners Arriaga and Williams. The Commission Liaison to the Inspector Committee, I'm going to appoint myself for the 1 meeting between now and when I think I will be gone, so that maybe somebody new will do that. For the Commission Liaison to the Education Standards Advisory Committee, Commissioner Wilkinson. For the Texas A&M Real Estate Research Center Advisory Committee, Commissioner Miller. And for the Texas Real Estate Inspector Committee, I'm seeking some comments from Mr. Slagle, right? Or we're not doing that today? Are you going to speak to the Inspector Committee appointments? Yes, I'm sorry. Commissioner Arriaga, prior to the meeting, thought you, and we both thought you were going to do that. Thank you.
I apologize for not paying attention. Tony Slagle, Deputy Executive Director of the Real Estate Commission. So just to give a brief understanding, the Inspector Committee was, or is, the Inspector Interview Committee is Commissioner Arriaga, he's the chair, and the chair of the commission appointed Fred Wilcox and Larry Foster, both inspectors, to be members of the committee. The Inspector Interview Committee reviewed all the applicants that were received for the vacancies on the Inspector Committee and recommends the following for the chair's consideration. Number one, to reappoint Lee Warren as an inspector member of the Inspector Committee for an additional 6-year term. Number two, reappoint Barbara Evans for reappoint Barbara Evans as a public member of the Inspector Committee for an additional 2-year term, and appoint Robert John Dean from Aransas Pass as a public member of the Inspector Committee for a 2-year term, and Dave Motley from Garland as a public member of the Inspector Committee for a 2-year term. The selected applicants for the remaining inspector member vacancy will be interviewed on Wednesday, February 13th. After completion of the interviews, the interview committee will provide its recommendations to the commission chair for consideration and appointment at that time.
So do we want to appoint those now, or you want to hold on the whole thing, Commissioner Arriaga?
Don't really know what the process would be, but want to address something else when we finish with Tony. Tony, those people we reappointed were continued because by process they can. So we can reappoint them right now, I guess, and then wait for the other interviews on Wednesday to reappoint those later.
Well, and the thought process also, sir, was that because public members are so difficult to get, and we received a few public member applicants, to the committee had recommended appointing them to fill those positions as well. And then just the interview the remaining inspectors for the remaining inspector committee vacancy on Wednesday, and then provide a recommendation at that point.
Don't need to vote because they continue anyway.
Well, we'll go ahead and reappoint those people, and then when the interviews are completed, we'll come back on the May meeting agenda. Someone will do that.
And then when you finish, I'd like for you to consider also appointing a commissioner to replace me. I've been there for 2 years, and it's a very lively group, by the way, and very hands-on. You're going to see later on today that they have some. It's not always by consensus. There's always an idea that some people can do better. So also like commissioners to consider volunteering to be that commissioner for the inspectors also.
Okay. And I misspoke. Not all of those names that you said are reappoint, some are new. So
yeah,
the names will be appointed as you have mentioned.
They will be? Okay,
Yes.
Just thank you for clarification. I just wanted to make sure that was the case. Thank you.
Want a motion, Madam Chair?
No, we don't need, it's just an appointment.
Thank you.
Is it now time on our agenda for general comments from visitors on non-agenda items? I've received no white papers asking for that time. Does anyone have a comment on a non-agenda item that they wish to make? Are there any comments on non-agenda items? Seeing no one making any rush to the microphone, I will say that we are going into executive session to discuss pending litigation or obtain advice of legal counsel on agenda items pursuant to Texas Government Code 551.071. It is 10:15. I think we will not be back until 11:30. So, an hour and 15 minutes. So, we're done. We'll see you all. Meeting back to order of the Texas Real Estate Commission on February the 11th at 5 minutes till 12. And I'm going to hand the gavel to Commissioner Westcott to handle agenda items 7. Officially.
Thank you, Madam Chair. We have a number of these to get through, so just so everybody knows, all parties will be given 5 minutes to speak, and I would appreciate you very much sticking very strictly to that. We will begin with Texas Real Estate Commission versus Kristen Alyssa Smith's. That's number 329180722, and I would ask that staff begin since the ALJ had no finding here.
Mark Moore, Standards and Enforcement Services. Could you please turn to page 22? of your materials and look at findings of facts 7 and 8. This is all that this case is about. And if you've read that already, if you could look at it again, I'd appreciate it. I've read it a bunch of times. The first email is from a buyer's agent saying they're canceling the contract, which happens pretty frequently. It's during the option period. An inspection was done, and they said the issues found in the inspection were too much. The very next day, and there's a typo in the findings of fact, but the very next day, there was a listing announcement that went out to autoemail@showings.com, and it said in the second sentence, buyers paid for an inspection and backed out before they even received the report back. So it doesn't say what the email said before it. Most of the time when these listing announcements go out, no one ever sees that first email. This time we saw the first email, and it looked pretty clear to us that there was, at a minimum, some sort of misleading advertising here. We don't get many of these cases. This is the first time that any of us can recall that a misleading advertising case has come before the commission. Normally we have technical violations. Normally we settle these things. This time we had it. And this isn't the biggest deal in the world. Advertising violations are in the lowest tier. It's $100 to a $1,500 penalty for this. And our debate internally wasn't whether there's liability. Even though the judge disagreed, we thought this one was pretty clear on this. You had these two back-to-back emails, and they said different things. So we offered to, the debate internally was, do we do a warning letter or do a small penalty? We offered to settle for $500, which is at the low end of that range, about 28% of the range on that too. The broker signed, looked at it, saw the two emails and said, okay, I'm responsible for advertising as a broker. Inspector signed a separate order. This one went to hearing. We think this is an important case because it's misleading advertising. And remember the standard here under the law, which is tends to create a misleading impression. It doesn't even have to be blatant or a lie. I think this one is pretty blatant, but I don't think it has to be like right out there that we think the person's a bad person. And I don't think I'm not out in the industry, but I hope that when something like that happens, there's consequences, and that's what we're really here about, are consequences. I'm available to answer any questions, and the lawyer on the case is here as well.
Real quick, I apologize. At the beginning, I forgot to say that Commissioners Wukash, Feitmiller, and Wilkinson have recused themselves from this case. The staff, do anybody on the commission have any questions for staff?
I do, but I want to hear the other side first.
Very good. You may sit down. Mr. Newsom.
Yes, I'm Kent Newsom, and in the complaint proceeding, I'm the attorney that represented the respondent, Kristen Smith. The judge heard all of the evidence. The complaint was filed. The judge heard the witnesses. The judge reviewed the exhibits. The judge read all of the briefs that were submitted by staff as well as me. The judge considered all of the evidence before it and determined that the Real Estate Commission staff had not proved its case of a violation. The question, I think, for the commissioners is, was the proper procedure followed? Not so much, do you agree with the result of the court? Because I don't know if y'all want to get into the business of hearing evidence and understanding rules of evidence and arguing exhibits and all of that, but you are concerned about whether or not the procedures were followed. And in this case, all the procedures were followed. The complaint was filed, responses were heard, witnesses were summoned, witnesses were heard. The judge had the ability to admit evidence, to exclude evidence, to trust the credibility of the witnesses or distrust the credibility of the witnesses. And after hearing all of the evidence, the court, the administrative law judge determined that the state had not met its burden to prove Ms. Smith committed a violation of the act. And I will also be happy to answer any questions that you might have.
Does anyone have any questions for him?
I have a question for Mr. Renteria.
Yes, sir.
How much are we requesting that the penalty would be? And I see it in page 32, by the way. I just want to go on record.
We had, during the hearing, we did have other violations. So we did break it down. For this one, we were requesting $750 for this violation at the hearing.
And on page 32, it talks about misleading advertising, dishonesty, misrepresentation, and disclosure, non-disclosure of defect. My problem is that if I'm selling a property and someone's inspecting it, they back out for whatever reason, and they bring me a second contract, I represent the seller. I hope that they, the second contract, also do a inspection. Was that done for Mr. Blackburn?
There was an inspection done for Mr. Blackburn, yes.
And he closed on the property after the inspection was done?
He did close on the property after the inspection was done. There were some issues with the inspection that failed to disclose some defects in the foundation. And in this case, there were other respondents. One of the respondents was the inspector for Mr. Blackburn.
Mr. Blackburn is the second purchaser.
There was a original purchaser that that Ms. Story represented, and he terminated the contract through his agent. And that's what led to this listing announcement that said the property is available again. And then Mr. Blackburn's agent was one of the recipients of this advertising. And pursuant to that, Mr. Blackburn made his offer, and his offer was accepted. And then the transaction proceeded.
Counselor, it's not very clear. Was there a first inspection ever completed?
There was a first inspection of the property. During the inspection, the buyer and the agent were present. Ms. Story was the agent for that buyer. And Mr. Chambliss, I believe, was the client, Chambliss inspection. And they were present during the inspection. They found a significant amount of water that was just standing underneath the foundation.
Did the second inspection find that also?
The second inspection, I believe not. I believe there was some time that had lapsed, and there was, I think the water maybe had receded by that point. I mean, I don't have all the facts from the new inspection, but we did find that the inspector did not follow the standards of practice, and he was disciplined. There were deficiencies, I believe.
Was the second inspection presented in the record of this case?
The second inspection, I don't believe the second inspection was presented, because
Then
the
it's not
issue.
appropriate to talk about the second inspection
I
when
was
you're
just
talking
answering
about
the question.
this case.
The reason I
Thank you
bring
for
it
the
up,
heads-up,
Counselor,
Christian.
the reason I bring it up is
Understood.
because it does not make sense that someone buys a property with an inspection saying, hey, you got problems, and then turns around and files a complaint.
Certainly, and that's a valid question. However, it's not in the record
I hear you.
before the commission.
We can only consider what's in the record.
Right. I hear you, but still, common sense to me does not, the dots are not connected. Thank you so much.
Sure. Any other questions?
Does anybody have any questions for Mr. Newsom? Or Mr. Newsom, would you like, you still got 3 minutes left if you'd like to speak any further.
I'd like to add this. Obviously, to hire a lawyer to come down to Austin, try a case, which took many, many months, to come here today, this is not inexpensive for Ms. Smith. And the argument seems to be made that she had an opportunity for $500 just to let this thing go. She didn't want to do that. She was accused of violating the License Act. She was accused of really fraudulent and being dishonest in the proceeding. And at great expense and time to her, she said, I didn't do this. I want to be able to prove, or I want the state to prove the violation of the act. And the state tried. You've heard some of the arguments today. The judge didn't buy the arguments then. And the judge said there was no violation of the act. There was no dishonesty. There was no misrepresentation, or at least the state has not proved that. And so I think it's not a fair argument to say that she could have simply avoided this by a small fine. And with that, I'll answer any questions that you might want to have.
Did Ms.
Smith.
have knowledge that
No.
there was, what did she hear from the selling agent on the first transaction?
The evidence that
Ms.
came up.
Stoling,
Yes, ma'am. The evidence that came up with at trial was one communication from the agent who represented that first buyer, who said, the agent said, and this is in the record, I think that this was, I think as a result of the inspection report, this was too much for my buyers. Okay? That's what the agent said. Now, that buyer was not a witness in the case. That buyer did not testify. There was an objection made to the testimony of this agent who said, I think such and such. How would this agent think anything unless it was just her own conclusion, her own speculation, or she was repeating what her buyer had told her? Either way, that is inadmissible evidence. The state had the opportunity, the commission had the opportunity to actually call this buyer as a witness, have him testify, why did I terminate that contract? They didn't do that. And the judge found that the commission, the Real Estate Commission staff attorneys had simply not proved that Ms. Smith knew of any problems, that she withheld problems or concealed problems about the foundation. They did not prove that and found, therefore, no violation of the act by Ms. Smith.
Thank you.
Any further?
Did that answer your question, ma'am?
Yes, you did.
Any other questions?
Anybody? I'm keeping track of everybody's time here, I promise. So, Mr. Moore, if you want to take any time, you've got 3 minutes.
Keep in mind here that this is a recommendation. The commission gets to decide these cases, not the judge. Obviously, the judge disagreed with us. We're not asking to change anything in the record. We're accepting the findings of fact here. Number 7 and 8 is all you need to look at. And regardless of what happens today, show this page 22 of the material. Show that to people. Show it to non-license holders. Show it to non-lawyers. Show it to your spouse. I showed it to a bunch of people in our office because I was like, am I missing something here? Am I missing something? Is this how the business is? Is this the industry? That you can say these sort of things. Every person who looked at it had the same reactions, like, no, that second one's not accurate. It's blatant. I got pretty strong comments from it, and this without me saying anything to sort of lead it one way or the other. Thank you.
I think we've heard quite enough here, unless you have any other questions.
With all due respect, Counselor, I disagree. When I read it the first time, I didn't see anything wrong. Read it the second time, I could read into things, but that's not me. I can assure you, as practitioners out there, we have a fine line that we have to walk sometimes, and sometimes we mess up, and we say we're sorry. Hopefully we do. I do not see any problem with honesty, trustworthiness, or lack of integrity. I move, Mr. Chairman, if I can, that the Commission reject the PFD and exercise its authority under Government Code 2000.058 to modify the facts of findings of law because the ALJ did not properly apply the interpret matter.
I think you're meaning to make the other to accept the ALJ's finding.
Exactly. And that we agree with the ALJ and make sure that the judge was correct. Got it.
I think does that work as a valid motion to accept the LJ's?
So just for the
motion?
record,
Yes.
to make it clear on the record, the motion is to accept the ALJ's PFD.
Got it.
Second.
Second, I have a second. Any discussion?
I'd like to bring in another motion, and I'm not sure when.
Well, let's rule on this one first, and then if we need to do anything else after that, we will.
Well, I think she can amend it, but
If you're welcome to amend it, but either that or we're going to hear this motion, though.
Okay.
So, a motion is second. All in favor?
Recalling that 3 people are recusing
Yes, that
from
whoever's,
this vote.
if you're recused, please don't vote. All in favor, please say aye.
aye.
Sounded like the motion carried. All opposed, say same right. Motion carries. Moving on to 7C, which is TREC versus Oscar A. Beltran. B, I'm sorry, I skipped one. Oh, there. Yep. Apologies. So docket 329184836, Teresa Lynn Stevens versus TREC. And so is Ms. Stevens here? Anybody representing Ms. Stevens? Doesn't appear to be so. So staff, please.
Yeah, like with the previous case, the commission's at a crossroads here. We have 6 more PFDs to discuss. 3 of them were not what staff requested. All 6 of them are background history cases. 5 of them are crimes and how to deal with that. Some involve license holders, some don't. 1 is a violent felony. This one is a aggravated promotion of prostitution felony, and it's recent, and the person was 42 years old at the time it happened. So we agree with the proposal decision and recommend its adoption. I'm available for any questions, as is the lawyer on the case.
Any questions for staff? Discussion? Hearing nothing, I will entertain a motion.
Move that we accept the ALJ's proposal for decision to deny application.
Second.
I have a second. All in favor, say aye. Aye. Moving on to 7C. This is number 329184138. TREC versus Oscar Beltran. Mr. Beltran, are you here? Is anybody here representing? Great. We can begin with him.
Sure.
Yeah. Actually, go ahead and do a summary, Mark. Sorry.
This case involved a license holder with 3 violations, 2 DWI felonies, and also a failure to report the first felony. The judge, in I think a well-written opinion, recommended a 1-year suspension. He is on probation until 2027, and then the judge, after seeing our exceptions, also added a $1,000 penalty. We object, then that we think it should be revocation.
Mr. Beltran, you have 5 minutes, sir.
Good afternoon at this point. I do not have an attorney because you've seen the valuations in El Paso, Texas. It's kind of a bit of money to be spending on this, but I don't dispute the facts of the case. You know, I've graduated from UTEP. I have 2 degrees, 1 in marketing, 1 in management. At which point, during my graduation, after my graduation period, immediately after, I went into real estate. I chose this profession because I think real estate is just, it's a wonderful opportunity. It's a great way to, in a sense, be a business owner. A lot of what they tell you in real estate school is good to get you going, but they never actually tell you what you're actually doing. You know, in a way, you're a chauffeur. You're, in some ways, an expert in contracting. You have to be able to say, well, let's get a second opinion on this, or this may or may not be a big issue, interpretations, bookkeeping, ads, so on and so forth. That being said, in 2012, I did have personal issues, at which point I began drinking heavily, and it led to the predicament in which I am at now. I did, however, get a suspension in 2000, or not a suspension, but my, I guess, felony conviction happened in 2016. And I've been basically with TREC back and forth since then. In the past 2 years, I have quit drinking. I have also basically, in 2 years, had more transactions close than in the previous 4 years when I was going through my personal issues. That's just the closing. We're not talking about the actual contacts and points of contact that you have to have with people. For every 25 that you talk to, you might get 1 that actually closes. That being said, you know, within the 3 years that the case actually occurred, I have not received any complaints, and prior to then, I do not have any complaints from my clients. I feel that the decision in certain aspects is kind of an overreach to regulate personal behavior, and even though I do not obviously would want to be on the 1-year suspension, I do understand that I did sign a code of conduct as part of my licensing agreement, and there should be some kind of penalty. However, I would like to request that you uphold the suspension as opposed to the revocation due to the fact that it would affect me on a personal level above and professional level. Plus, I believe that the other stuff that is also part of the evidence, the efforts that I have made through the court systems to redeem myself, I would like to have the same opportunity from the commission as well. Thank you.
Thank you very much. Does anybody have any questions for Mr. Beltran?
Have a motion?
We have a motion?
I do. Mr. Beltran, are you on community supervision at this point?
Yes, sir.
Until when?
2025.
Do I have a motion?
I have a motion. I move that the commission adopt the proposal for decision and impose the following conditions: that Mr. Beltran must comply with the terms of his community service, and Mr. Beltran must not engage in unlicensed activity during the term of his license suspension. So moved.
Do I have a second? Second. All in favor, say aye.
Aye.
Any opposed? Motion carries. Mr. Beltran, we all congratulate you, by the way, on your rehabilitation, and good luck in the rest of your journeys.
Thank you. Appreciate it.
Moving on to 7D, this is number 329184258, Cook versus TREC. Is anyone here representing Ms. Cook? Is Ms. Cook here? No? Okay. Mr. Moore?
Yeah, this case also involves an applicant with background history. Unlike the other cases, it involves a civil judgment. It was real estate related. She asked to have it discharged in bankruptcy. The judge excluded it. Also had punitive damages as well, and there's been no payments on it. So we do agree with the proposal for decision and recommend its adoption.
Any questions? Entertain a motion.
Move that we accept the ALJ's decision to deny the license.
Second. All in favor, say aye.
Aye.
Motion carries. Moving on to 7E. This is 32918, and I would note a typo here. It's 4363, TREC versus Reese. Ms. Reese, anyone representing Ms. Reese here? Thank you. We'll let Mr. Moore begin with a summary here, and then we'll hear from you. Go ahead, Mr. Moore.
Yeah, this is a troubling case. I'm mostly going to defer to Mr. Herring on. He's really familiar with it. Just want to point out that this involved a sexual offense, and to my knowledge, the commission has never, or at least in the time I've been here, granted a license to someone with a recent sexual offense or not revoked someone with a sexual-related offense. And I can think of two in the last couple of years where the commission came out strongly against these types of crimes. I'll let Mr. Herring was the lawyer on the case.
Good afternoon. Staff believes this matter boils down to one question. How seriously does the commission take sexual offenses, specifically second-degree felony sexual offenses? The state of Texas entrusted Ms. Reese with a teacher's license, and Ms. Reese violated that most basic tenet of that license. Ms. Reese has confessed to having sexual contact with a student during a school field trip at which she was a chaperone. While charges for that crime were pending, Ms. Reese obtained a real estate license. After being licensed by the commission, Ms. Reese made a plea deal, and then that's when she confessed to having had sexual contact with a student during a field trip, at which time she was a chaperone. Ms. Reese twice failed to advise the commission of this plea. Staff recommends revocation of Ms. Reese's license. The SOA judge found that the state's position for sanctions was legally sufficient, but disagreed with staff's sanction recommendation and rendered her own. However, the question of sanctions is not dictated by the ALJ. You, the commission, have the sole discretion to determine what sanction is appropriate. Again, the question here is, how seriously does the commission take sexual offenses? Staff makes its recommendation understanding that this order is not issued in a what happens with this order gets issued won't be in a vacuum. Staff recommendation takes into account some bigger picture concerns. Staff asked the question, what message does the probated suspension suggested by the ALJ say to the public? Does it say that the commission doesn't care about sexual offenses? Does it say that the commission doesn't care about second-degree felonies? Does it say that the commission doesn't believe victims of sexual offenses? Does it say that sexual offenders should use real estate as a safe harbor while pending trial because the commission will allow you to practice real estate without interruption if you later confess to the offense? In the face of these concerns, staff recommends revocation. And I'll answer any questions you'd like.
Commissioner Stevens.
Did this agency receive notification from Ms. Reese that she had disclosed fully what had happened in 2015?
No. When Ms. Reese was applied, the charges were pending, and she did indicate those charges were pending. Then after she made the plea, she did not advise us of that. And then when she was getting her reapplying, she didn't advise us again that the plea had happened.
The file indicates that it was, perhaps I'm mistaken, but it's that Ms. Reese did provide full disclosure at the time that in 2015 when she was applying, And then her license was issued because the case was pending.
Correct.
Did TREC give some sort of written communication to Ms. Reese to update her case when there was a resolution?
I don't believe so, other than that it's required by our rules and by the statute that within 30 days of a plea of guilty or nolo contendere, you have to report that. That's why the ALJ agreed and offered and did the $1,000 penalty.
Thank you.
Sorry. I received clarification on the question that we do send a letter when they are issued their license. That's what our head of standards area told me.
Thank you, sir.
We'll hear from Ms. Reese. Anybody representing Ms. Reese?
Morning, Commissioners. My name is Tony Bertolino, and I represent Ms. Deanne Reese.
Okay.
Commissioners, one of the things we actually wanted to point out portions of the PFD in particular that Judge Kilgore, the ALJ on the case, had pointed out. In particular was the evidence that was presented, the testimony of character witnesses, as well as Ms. Reese's previous criminal law attorney. In particular, that would be on page 10 and 11 of the proposal for decision.
Page 128, page 129.
And I wanted to be very clear that Ms. Reese actually pled no contest, nolo contendere in this case. And the evidence in the record showed that the reason for doing that wasn't because she was guilty of the crime. Quite frankly, she was innocent of it. And this is something that she has stood by since all this started. Particularly, I had mentioned this to her criminal law attorney. And after talking with her family and deciding that the money, the cost, the blood, sweat, and tears that would go into something like this, she decided to plead no contest. This was not a guilty plea. In fact, to this day, she firmly asserts her innocence of the charges that were made against her. Despite that, assuming arguendo, the ALJ still took in consideration the testimony of key witnesses, including an affidavit supplied by her criminal law attorney. And essentially what Ms. Reese has done is that she's satisfied the factors under 541.1C-D. The ALJ recognized it. It's on page 13 of the proposal for decision. Among the factors that were considered was and the ALJ ultimately decided that the Commissioner's rule weigh in favor of Ms. Reese. That Ms. Reese had no other criminal history before or after this charge or this offense. She has a strong history of recent work. Her broker sponsor had an opportunity to testify to that. Her own clients were able to testify to that. She's made over 50 closings, is doing a well job, meriting the trust placed in her clients, and she has been compliant with the requirements of the criminal court. And as I mentioned before, she continued to have the favor of the sponsoring broker, which again testified in court about his support for her. Page 14, the witnesses that were presented were just compelling, and I wish there would have been a video of it and their presentation of the evidence and their testimony. But regardless of their understanding of her criminal record or background, what these witnesses did was they provided their direct observations of knowing Ms. Reese and her conduct as a real estate agent over the period of more than 2 years, which shows her fitness to practice real estate. And she has done a fine job. In fact, it would be a harm to lose a real estate agent like Ms. Reese. So I would hope that the Commissioner would consider adopting and ratifying the Judge Kilgore's recommendation in the PFD.
Counselor?
Yes.
Got a question. Counselor, I read someplace that Ms. Reese did try to reach you and ask you a question about notifying the commission or the staff that what was going on. And apparently you had an operation, you could not do that. Tell me more about that.
I was not representing her in the criminal law matter.
It was a separate attorney.
I see.
Yes.
And the record shows the previous attorney had hip surgery, and there was miscommunication, which, of course, the ALJ goes into the mistake of fact.
She tried to notify someone and got lost in the mail.
That is correct. And her criminal law attorney actually testified to that in the form of an affidavit.
Saw that. I feel sorry for educators. This world has changed. And students sometimes becomes a predator. And in reading what I read, I could not actually see anything that I was convinced that what was being said is true. But then I'm not the judge. So I have some, this basically mirrors the first motion that he said, she said. And it's hard for me as a commissioner to make a recommendation that I'm not really sure about.
Anybody else have any questions?
I have a question for our staff. Thank you.
You may step down, Mr. Bertolino.
I'd just like to comment. Ms. Cooper is the one who discussed on the testimony, and our mission is to protect the public.
Correct.
But in this case, even the administrative law judge, and I'd like to point out to page 131, second paragraph, it says that the only specific concern Ms. Cooper discussed in her testimony is a concern that she referred to repeatedly was a worry that Ms. Reese could come upon a child while showing a home. And the implication is that Ms. Reese would seek to take sexual advantage of the child, and this concern is not at all based on the actual specifics of the offense. And no child was involved in the crime. And to which Ms. Reese pleaded no contest. And the undisputed fact is that the student was 18 years old, and any concern that Ms. Reese would sexually assault a child is unfounded conjecture. Further, on page 131 as well, there's, as Ms. Reese's attorney provided information that there's no other criminal history before or after. She has strong history of recent work. So I just like, our job is to protect the public, but also it's very important that we do not look for double jeopardy. To emphasize that what we were looking here was that the Ms. Reese failed to communicate the second time after her license was granted that there had been a change. Perhaps she should have communicated, and perhaps the agency should have, perhaps we should have some kind of follow-up, because a lot of people do not know procedure. I do give Ms. Reese credit because she did notify the agency when the offense occurred.
You're correct. She notified the agency on her application that an offense that a charge was pending. That happened, and then once there was a plea deal in that, the agency was not notified, and then on the then again when we were going through her reapplication or her renewal, she didn't advise the commission of that fact. Now the judge found, as a finding of fact, that the second time was an inadvertent mistake, and so we're not really talking about that. We're just still focused. But the judge did find, of course, that it was her responsibility to notify on the first time, and is an issue to fine for that. But as to the larger issue, I believe one thing I want to be clear is that the ALJ found that staff showed that we have proven the elements of the case that allows us to issue a sanction. And the ALJ had their opinion about a sanction, and staff has made its recommendation about a sanction, and it's just up to the commission to decide what they think is the appropriate sanction.
Thank you, sir, very much.
Got about a minute left if you'd like to add anything.
Real quick, I do want to emphasize that what happened, and it was pointed out by the ALJ, was the mistake of fact, and that was the mistake of miscommunication with her criminal law attorney. Affidavit record shows that her criminal law attorney did in fact receive an email from her acknowledging that he had received an email, but just didn't go follow through with presenting the proper notices to the Texas Real Estate Commission. However, he did do it with TEA back when all of this came about, but just failed to do it with TREC. So she's not an attorney. She hired a lawyer to do his job. For whatever reason, whether he was involved in hip surgery, personal problems, whatever it may be, he just didn't do his job. And again, that's why the mistake of fact stands. And I would like to, you Ms. Stevens, pointing the fact out that this was not a child, this was an 18-year-old, first and foremost. But above all of that, again, Ms. Reese is adamantly asserting her innocence to the charges.
Thank you. That's the expiration of your time. Any discussion? Can I entertain a motion?
Mr. Chairman, I'd like to move. I move that this commission adopts the PFD with the following change to the discipline as authorized by law, granting the agency the authority to determine the appropriate discipline. That this commission adopts the finding of facts and conclusions of law, except the commission modifies conclusion of law 9 to read that Ms. Reese's license should be suspended for 1 year and the suspension be probated, conditioned on her compliance with applicable law, and a penalty of $1,000. And the reason for that is there are other cases in which you tried, and I believe that you had good faith, and that's my opinion, and that's why I'm proposing this. Thank you.
Second.
Second. A second.
Motion is second. All in favor, please say aye.
Aye.
All opposed, same right. Appears that the motion carries. Moving on. Agenda item 7F. This would be number 329185333, TREC versus Mr. Kenneth Levon Hayes.
This case involves a broker who strangled his wife, and it's a third-degree felony. And what the commission has done in the past on these kind of cases, there was a case called Cavalier, which is about 2 years ago, applicant who also strangled his then wife. The commission denied that person a license. And then as recently as the last commission meeting, this body revoked a longtime broker who had engaged in domestic violence felony with his wife. That other one was Giles. He waved around a gun and got a felony on that. This one, I think, is worse. It's someone putting their hands around the neck, impeding circulation. He also violated a protective order in addition to that crime. Because of that, we think revocation is appropriate. I'm available to answer any questions, as is the lawyer on the case.
You may step down. Mr. Hayes, anybody representing Mr. Hayes present? Anybody have any questions for staff? Hearing nothing, I'll entertain a motion. Anybody need help constructing a motion? Anyone? Bueller? Yes.
Mr. Moore, just to remind us, if you would, what staff requested in
Staff
comparison?
requested revocation.
Revocation.
And the judge said probation.
Fully probated, suspension fully probated.
Correct, and that's inconsistent with what the commission has done in the past on similar types of cases, in our opinion.
And the penalty you requested, the staff requested?
Revocation.
No penalty, no money.
Oh, there was a penalty on that. We didn't disagree with that part of the opinion.
$1,000.
$1,000.
Yeah, we didn't disagree with that, just the sanction of revocation versus suspension. Sorry about that.
Okay.
Mr. Chairman, my dilemma is that we got two extremes. One's to deny or revocate his license, and the other is fully probated 3-year suspension, if I'm not mistaken. And two extremes, and I'm confused because if I'm a member of the public and a realtor says, I got a house for sale, I want to go look at it, and I knew that this person had a charge like this, it scared the heck out of me. So I do not understand why the difference of opinion. Something is happening sometimes, and the last several times we met, we've overturned the staff several times, and I hate doing that because you guys work too hard and actually do a lot of work to make sure that we follow the rules, but sometimes we bend the rules. I don't think we ever broken a rule. So I'm not ready to make a motion yet.
Kristen, I think you had some to add.
Madam Chair and Commission members, I think the ALJ was balancing the crime in this case with the extensive rehabilitative efforts that were presented in the record at the SOA hearing. And you can see those at page 167 of your materials in findings of fact 12 and 13, as well as the testimony that was presented in the record at pages 164 and 165 regarding the respondent's rehabilitative efforts. The respondent in this case is on community supervision until 2020, and a 3-year probated suspension, if that's the decision the commission decides to make, would extend the probation until 3 years from the date of the commission's order. So that would go into 2022.
The biggest sin that I saw is failure to notify the commission that something had happened. That bothers me more than anything else. Was he trying to hide it or not? So that's why I'm confused on how far I want to go in correcting the wrong that was done.
Of course, and the ALJ imposed a $1,000 administrative penalty, as staff sought in this case, for the failure to notify the commission of that conviction. Now, I just want to remind the commissioners that those are not the only two options that you have. Staff sought revocation. The ALJ imposed or is recommending a 3-year probated suspension. There are other options available to the commission. You could extend that probated suspension if you wanted to, or you could shorten it as we did in the previous matter that was just discussed on the agenda.
And Mr. Hayes is not here.
He's not.
Okay. That bothers me when you see people that have the guts to come up and talk to us, which I respect, because we're the last word supposedly. Mr. Hayes, many things could have happened that not be here.
Commissioner Miller, I think you had something to say.
I'm willing to move that we penalize him the $1,000 and extend the probated sentence for 3 more years. Did I understand that?
To accept the that sounds like it's accepting the ALJ's.
Yes.
3 more in addition to the 3, to a total of 6, or a total of 3?
It will extend the 1 more that the ALJ has put in for 2020, right?
No, they did.
No. So that's the community supervision. It lasts until 2020.
I want 3 more.
So you'd like to accept the ALJ's decision. So a total of 3 years.
That's what I'm moving. Thank you.
I have a motion. I have a second to accept the ALJ's decision in this matter. All in favor, say aye.
Aye.
Aye. Sounds like the motion carries. Moving on to agenda item 7G. This is TREC versus John David Tyler, number 329183816.
This was an applicant with a lot of criminal history. It went from 1998 basically to the present. Is involved with criminal history. He disclosed some of the crimes, didn't disclose all of them, didn't complete the terms of a supervised release, and basically it's repeated in multiple violations, and 3 of the 5 convictions occurred in the 4 years before he applied for a license as well, and there were a number of crimes he didn't tell us about that were pending as well. So,
I'm ready to make a motion.
Mr. Tyler, I believe, is here.
And also have the lawyer on the case if you have questions for Mr. Herring as well.
Great, thank you. Mr. Tyler?
Hi, good afternoon. My name is John David Tyler. I'm here to speak briefly to try and attempt not having the application denied. Very quickly, I just want to point out one thing. On page 2 of the proposal for decision, and this is really kind of a moot point, but since I have the public arena to say it, on the offense that's listed under June 22nd, 2015, it incorrectly says that the offense occurred in July of 2014 and actually occurred in January. Not trying to deny that it didn't happen, but that's just an error on that. You know, the 2 biggest, there was a lot of bullet points of omissions and errors and things that highlight a lack of honesty and integrity and trustworthiness. And I just wanted to address 2 of those very quickly. The failure to disclose claim, there were 3 things that when I did the application, one of them was a 20-year-old bad check to Papa John's that I had honestly just completely forgotten about. 2 were out of state. I know now that I should have included everything, but I did not include them because they were out of state. However, when it was brought to my attention, I very quickly and completely provided the information to the Enforcement Committee as requested. To the issue of the arrests at the end of summer of 2017, I had a criminal attorney at the time who told me that since those charges had been, they weren't indicted at that time, that I wasn't actually charged with anything officially, so that's why those were omitted. I wasn't in any way, shape, or form trying to hide or conceal what was going on. In fact, 2 of the 3 that are referenced occurred after the initial application, to be honest. Since then, those have been settled to where 2 were dismissed. 1 I am currently on a misdemeanor probation until November of 2020, I believe. And if you look at my background, which is littered with downturns and mistakes that I am extremely remorseful and shameful of, and now they're up there for everybody to see, but it's rooted in alcohol abuse, a very bad and unaddressed at the time addiction to alcohol. I have been sober now for 411 days, and I see that sobriety as a chance at a second life, and I was hopeful that building a career in real estate could coincide with that rehabilitation in life. I do currently work for a broker as a property manager who is completely willing. I've known him since 2009, and he's willing to sponsor and hold the salesperson's license if one were to be issued. And I know that all of this points to a lack of honesty, integrity, and trustworthiness, and instead of using the limited time that I have left to ramble on about how I don't think that's the case, I think the best thing I can do is...
You have 2 minutes for the record.
Yes, sir. Thank you. Is point to the last paragraph of a letter from a reference that was provided and stated November 28th of 2017. This is one of the reference letters that I provided when requested as part of the background investigation. And it says, as someone who travels quite extensively internationally, I find my personal time to be at a premium. When David approached me about writing in this letter stating all of the specifics it needed to entail, I suggested that perhaps he could compose said letter for me, which I would review, sign, and return. To this, he flatly refused, stating that would be a lie. This, to me, speaks volumes to his integrity and honesty, as I believe it should to you. Thank you.
You step down. Anybody have any questions for him or for staff? Hearing nothing, I'll entertain any motions or any discussion.
Mr. Chairman, Mr. Tyler, I appreciate you being here. It means a lot to me. The problem is the list of stuff that went down, for lack of a better way of saying it, is not good. And right now, it's not the best time to be asking for a license. Saying that, Mr. Chairman, I'm ready to make a recommendation that his application be denied.
Second.
I have a motion, I have a second. All in favor, say aye.
Aye.
All right. Motion carries. Thank you, Mr. Tyler. Congratulations on your sobriety, and best of luck to you. Now that we are done with all of this, I will gladly pass the gavel back to Madam Chairman.
Call agenda item 8, discussion of possible action to authorize settlement of recovery fund claims. Who's got this? Ms. Horman?
Good afternoon, Madam Chair and Commissioners. Kristen Warman, Deputy General Counsel. The first item before you is Recovery Fund Claim Number 18-020, Fountain Vista Homes, LLC versus Roy Ornelas and the Wynn Group, LLC.
Commissioner Leonard, did you have a motion on this case?
Moved that we authorize payment of $30,600 in actual damages plus interest, court costs, and reasonable attorney's fees less $23,000 for settlement payments received from other parties.
A motion to have a second?
Second.
All in favor, say aye.
Aye.
Opposed, no. Motion carries.
Madam Chair and Commissioners, the next matter before you is Recovery Fund Claim Number 19-004, Clifford Day versus Catherine S. Vigiano.
Commissioner Arriaga, do you have a motion on this case?
Madam Chair, on Claim 19-004, I authorize payment of $2,771.70 in actual damages plus interest and court costs.
So you move that we authorize that? Is that what you said? Okay. Do I have a second?
Second.
All in favor, say aye.
Aye.
And opposed, no. Motion carries. Agenda item 9, which are reports from the various folks. Mr. Oldmixon, are you first? No, that's not public.
Madam Chair and Commissioners, good afternoon and welcome to your greatly extended quarterly business meeting. We sincerely appreciate the extraordinary commitment you have each made during the Sunset Review process to be available for all of the extra time needed to consider data, research, and options for implementing the requirements established by the Sunset Commission decision report. Your staff and the stakeholders who rely on your guidance and action are grateful for your generosity. And I want to say a special thank you to all of those license holders who have made a special effort to be here to witness the extent of the efforts that this commission puts forward to protect the public. In your materials, in the front of your binder, you will see there a TREC key contact list and TREC Q&A resource guide. These are updates to the contact information that is with respect to your staff because we've had a few changes, and we will continually bring you those updates as we, if there are any staffing changes or as staffing changes occur. In the pocket in the front, yes.
What's your own?
No, I took it with me. So first of all, let me introduce a new division director. Steve Rapp began as the new Director of Information and Technology Services Division in January. Steve most recently worked as the Technology Director at the State Library and Archives Commission and also has significant experience with licensing agencies, including the Board of Pharmacy and TDLR, and specifically with the Versa database that this agency uses. Steve has a degree in enterprise management from Northern Illinois University, and he enjoys spending time camping, hiking, kayaking, and other rugged outdoor activities with his wife. So please help me welcome Steve to the team. I'm also very pleased to announce that Jennifer Wheeler and Denise Sample will both be promoted to division directors effective on March the 1st. As the current managers of the education and licensing departments, respectively, each has demonstrated the ability to lead a focused program effectively. Each will be given the opportunity to further demonstrate their potential for leadership of these two crucial areas, which will assume the status of separate divisions as of March the 1st. Please join me in congratulating Jennifer and Denise for their new roles. We expect great things from these two outstanding performers. And so they'll make their first reports to you because their promotions become effective on March. So at the May meetings, you'll get to welcome them. Are they here? No, they're working hard. Yes. Running their departments because Gwen is here. Now, our current and long-standing Education and Licensing Services Division Director, Gwen Jackson, will be taking a new position in the Education Division focused on direct interaction with our many fine education providers. Improvement of course delivery effectiveness and compliance will be the goals of her efforts. This is an area we have long planned to address more directly, and with the addition of the appraiser board's education enhancements, it is time for that area to receive this additional attention. And our long-serving TREC General Counsel, Carrie Lewis, has given notice that she will be retiring early in May of 2019. A search is underway for a new General Counsel as soon as possible. We hope to have significant overlap time so that Carrie can transfer as much knowledge as possible to assist the agency with this vital transition. We will miss her excellent contributions to this agency for over 9 years, and we will say a formal farewell at our May meeting. Adding additional focus and resources to our education and licensing areas will enhance our customer service response and make it more effective. Recognizing and retaining valuable talent and finding new exceptional talent are ongoing challenges for any team, and if managed well, will produce even better results. I don't think I need to reiterate the amount of work that has gone into addressing all of the sunset issues. I can only say that it has been quite a challenge these last 4 months, and both you and your staff team have responded tremendously. And we have a lot of work yet to do in today's and tomorrow's meetings as well. So unless you have questions for me, I will turn it over to the directors for their regular reports.
Thank you, Mr.
Okay, thank you.
Thank you, Mr. O'Mixon. Mr. Slagle? I thought it was Mr. Hood. Changed your mind?
Well, no, I'm giving I apologize, the executive director misspoke. I'm giving a deputy director director report to talk about customer service issues and answer any questions you may have on that. And then I will introduce the new reception and communications director. So good afternoon, Madam Chair, Commissioners. Tony Slagle, Deputy Executive Director. I again want to provide a brief update on customer service. I sent out my monthly email at the, I believe it was last week sometime, to give you an update on where we stand on certain numbers. I'll just reiterate those real quick. In January, we had almost 27,000 calls. That was 12,000 more calls than we received in the month of December, for an 82% increase in calls. 13,792 of those calls, or 52% of them, were handled by staff. They were answered directly by staff. 8,000 of them, roughly 8,000 of them, were calls returned through the courtesy callback feature or routed to other personnel in the agency for assistance. We had an abandonment rate of 18%, which was an increase from 14% of the prior month, and the average hold time in January is 15 minutes. It was 10 minutes in December. I did want to let you know that this morning, and then during the executive committee, not the executive committee, when you guys stepped out to discuss things, I checked for this month just to give you some on-the-spot updates on where we are. So far, I know it's a small sample size, but for this month, so far, we are at a hold time of around 10 minutes. We have a 13% abandonment rate, which is obviously lower than the 18% and on track to be lower than the month from December as well. And 64% of the calls have been handled by a staff member on the first call. Obviously, we're still working towards getting those numbers down, but I did want to give you an update on those numbers as of today, where we are for this month. I also wanted to explain one of the reasons the hold time likely went up and the calls were increased was in December we discovered there was, we're still learning some of the intricacies of the phone system, unfortunately. We discovered there was a cap, our official cap or governor on each queue of 30 calls. So when you hit that cap, you either got a busy signal or you're redirected to call back again. We thought it was more important that people have the opportunity to get be addressed by someone and the time they call. We knew that would increase the hold times, and we removed that governor, which let the doors open, so any call coming into the system now goes into the system. There's not an artificial cap. Thereby it increased the calls and also increased the hold time because the staff was handling more calls. We knew there'd be some frustration, and we apologize for that, but we also knew we were going to get at least mid-January 2 people that were training in December to start answering the calls. They did start at the towards the end of January, and we have, I'm happy to report publicly, as I did in your update, that we have hired 8 additional people to 5 full-time and 3, I'm sorry, I believe it's only 2 as of right now, temps to work on the phones. They'll be beginning training tomorrow, and will hopefully be on the calls later next month. I'll let Mr. Hood introduce them later on when he gives his report. Are there any questions about any of that before I continue? Okay, thank you.
Oh, hang
yes,
on.
sir.
Mr. Slagle, at the risk of pontificating here, we are a customer service oriented agency. We have 2 very diverse customers, but we're looking for the same thing. One is the people of the great state of Texas, and the other is our 190,000 license holders. What do we need? The elephant in the room is this communications department. And I know Mr. Hood just started. I hope he's figuring it out. I'm sure he will. What do we need? What do you need from us? What do we need as an agency to fix this call hold time, abandonment rate? I want to see an ultimate good. I was very disappointed, and I understand the executive committee may have made some adjustments to this, but I was very disappointed in our 5-year plan to see that we still have a goal of a 10-minute hold time. That's completely unacceptable. Completely unacceptable. I'm surprised the abandonment rate isn't higher. In my opinion, the goal should be when somebody calls, the phone is answered. Now, maybe that'll happen and maybe it won't, but I would like to see an immediate call hold wait time change to 5 minutes. And as soon as we hit that goal, we need to change it to 3. And when we hit that goal, we need to change it to 1. And we need to continue to keep trying to improve on this. And I know not only me, but the rest of us have been sort of pontificating on this for a year. And I'm not seeing any improvement. So I'm not smart enough to know what needs to happen. I know what needs to happen. I'm not smart enough to know how to do it. We have resources that we can discuss later in our budget conversations and so on, but we need to know what you need or what Mr. Hood will need.
Well, I will answer your question this way. We are finally at a point. We're adding the people we're adding is almost going to double the size of the call center that we currently, in terms of people being able to answer the calls now. So I understand your frustration. We feel it as well, and I understand that we need to get this fixed as soon as possible. The thing that I struggle with that is I want to make sure where it's done correctly as well. So my goal has been to make sure that we do things so that we don't have to revisit this in a couple of months. In other words, in the past we've done these incremental things, and we've had to go back and address them as they come up. And working with Mr. Hood, we've been, in the short time he's been here, we've been working on ways to establish processes in place that are sustainable, so that when we hit this goal, we'll be able to forecast and know, okay, in order to get below 5 minutes, we need to add these people, and we need to do this. We're looking at starting a process of hoteling, which will allow people to work from home part of the time, as well as work work in the office, and Mr. Hood has done that in previous agencies, and his experience is that increases the productivity from the call center when you do that. So there's all these things that we're working on to make sure that we have a sustainable goal of reaching a low hold time. I know, again, I don't know what to say other than I do understand the frustration, and we are working on that. Adding the 8 people will help. They do need to be trained, but in that training process, we're working on ways to get them on the phones as much as possible during that time to help with the peak times, when the peak times we deal with throughout the day. And we have an ability to know what those are, so we can move those people around.
Do you have the resources to do that today?
Well, I believe we do. Right now, we've never had the call center staff up to the point where we're going to for a sustainable period of time. So we've constantly been dealing with trying to get people into the call center to answer the calls, and we've had a limited number of resources to be able to do that for various reasons. People retiring, people leaving. We're going to have, I believe, and Mr. Hood can speak to this. He knows the exact number, but I think we'll have 21 people available to answer the phone calls, which is the highest number we've had at least since I've been promoted to this position, if not before that. And so I guess my answer to that is I'll be able to let you know once those people are on if that's a sustainable move in the right direction. We are adding more people. That's helpful, but we're also doing other things. And I don't want to steal his thunder, but he just recently was able to gain significantly more control over moving people around in the queues. Prior to last week, we had to go to DIR every time we wanted to move a person from one queue to another. We had to reach out to them and ask them to do it, and they promised they could do it within an hour or two, but within 2 hours the emergency with wanting to move them was already over with, so it didn't help us at all. He has gotten DIR to agree to give us better access to that, so we are able to move those people within the queues ourselves and answer to those increased volumes more directly. So he's really it's been impressive for a short time here, the amount of things he's been able to bring to the table to create a sustainable environment, so we know what we need to do to keep the abandonment rate down, people on the phones longer, and the hold time down.
Do we have a relatively high turnover in the call center?
I don't know the answer to that. I know that we've had several retirements recently from people who've been here for a while. I know we've hired several new people over the last 6 to 10 months.
What I'm getting at is we have 21 people available.
Yes, sir.
That doesn't mean 21 people are standing by the phones at any one time. That means there's 21 people that have been trained to do this function. At any given time, right now, how many people are answering phones?
11.
11, huh?
11, but that's not including, when you add these 8 people, that'll get us up to 21, and those people will be dedicated to the phone lines.
And instead of and believe me, I'm asking questions.
Yes, sir.
What I want to make sure of is that you and Mr. Hood have the resources available, which we can provide. And like I said before, this is the elephant in the room, and it is my personal frustration, as you may know by now.
Yes, sir.
That, and I'm not going to beat him up today. He's been here a month.
That's what I'm here for.
But he'll still be here in May, and so will I. And what I want to make sure of is if we've got 21 people, why don't we, and I don't want to throw money at something, but maybe
Yes,
this
sir.
is something we need to throw some money at and make it 41 people.
Well,
And if 41 people does the job, we've done our job.
Yes, sir. I understand.
And maybe 31 is the number, but maybe we hire 41 and we let some attrition take us back down to where we're in an acceptable range of communications with the people that we serve.
Well, again, to speak to just sustainability, there are other things, unfortunately, in the mix. Instead of just hiring people, we've got to have space allocation, which we've got to deal with. We've got to make sure that this pilot program we're moving forward with, where people can hotel and work from home, that works and that's sustainable. Once we get those things in place and they're working, then it makes it easier to start bringing more people in, because we have the ability.
Those are all the things we need to know, because until all we see are the results, and the results stink. So I want to see the results happen. I don't know how to make them happen. Hopefully Mr. Hood will figure out how to make those happen. You're right, I'm
Wait,
frustrated,
I got
but I
Commissioner
want to see some
Westcott.
progress.
I've got
Yeah,
Westcott, Arriaga,
I'm going.
Westcott.
Okay, go first.
Arriaga.
You're younger.
Then Williams.
Mine's very simple line of questioning here. That callback feature, press 1 if you'd like, to save your line. Is that functioning now?
It is, and I know there's been some frustration with people who were not getting callbacks. As far as I know, as of this date, that issue has been resolved.
Okay, so just a kind of a line of questioning going down regarding this callback feature. Approximately what percentage of calls are electing to use the callback feature?
Let me see here. So last month, I just need to look at this real quick. Last month we had 30% of the calls were DQ'd. That doesn't mean that they're using the callback feature. That also includes people that were transferred to other places. Probably roughly 20% or so.
Okay,
I would say.
So when we look at these numbers, average hold time, does that include this? Does that mean it took, on average 10 minutes also to call them back, or?
And the hold time is a term we've been using, but actually in the call center jargon, it's wait time. And what that means is you're getting, it's the average time it takes for you to get a hold of somebody, whether it be you're virtually on hold or you're actually physically sitting on the phone waiting for someone to answer the phone. So it's a combination of those two times.
Same question with abandonment. So does that mean is in this abandonment 13% of the time we called them back? Whatever, had it been an hour and they didn't choose to
No,
pick up
sir.
or
No,
something?
sir. That's if people choose to disconnect the call. I will say this, and this is just for your edification and information. I've read a lot of stuff over the last 4 or 5 months on call centers. I know more about call centers than I ever thought I would know. And industry-wide for call centers, not just on agencies, there is a higher percentage of abandoned calls for mobile call users for a variety of reasons. Either they get disconnected, they're walking to a store, they do something that they hang up. It's around 30 to 40% for abandonment rate for people who call in on a mobile phone. That impacts call centers across the board. That doesn't mean that we find it acceptable to have an abandonment rate at 13 or 18%. We're working on that, but I just, for your edification, wanted you to know that does factor in.
I know there's a list of questions behind me here, but just my last question. When was the callback feature fully implemented, working, everything's working with it? When did that happen?
Without any issues?
Without any issues?
Maybe 4 weeks ago. But it was working about 90% up to that point. From
approximately when?
From the end of August, I believe, is when we implemented it.
Mr. Arriaga?
Madam Chair. I also have a lot of questions, but I really want to get to item 19 real quick. So that way people that are here for their visits will understand, and we can always go into it, because I actually got a tour this past week of the area, and once you see what we're doing, you understand our dilemma. But we're not going to solve it right now, but I recommend, if it's okay, we continue this discussion after we finish item 19.
Okay, I have Mr. Williams wishing to ask a question.
You spoke about ramping up.
Yes, sir.
Do you have a number in mind of new hirees and a time frame with a potential location so we can get ahead of the process?
The short answer is no. The long answer is, and I spoke with Mr. Hood about this last week, it's difficult to know exactly how we're able to handle the calls because several things have happened over the last week. We hired new people. We gained control over the queuing. We're looking at a way to get the board calls disengaged with the TREC calls, and what that will do. Board calls are typically more complicated, so if someone's on a call with a board call, they take longer to handle those calls. Once those are moved to someone else, that should decrease the amount of people on the real estate side that have to wait to hold for the phone. So the long question is, the long answer is, we won't know until all of that stuff kind of goes into place, and that likely won't happen in terms of the people being on the phone fully trained for another 4 weeks. And I hate to say that, but again, I understand the frustration of getting this done quickly, but I also want to make sure it's done correctly as well, because I really don't want to have to revisit
I don't think it needs to be done quickly. I know it needs to be done correctly. From where we sit, we just need a time frame so we can help you.
I think we'll probably have a better understanding of where we are in terms of people and the implementation of these, not only the hoteling and people being able to work from home, but the greater control over the queue. I'll just throw out a rough estimate of 4 weeks. We'll probably have a better idea to know where all that is going, to where when I give my report in March, I'll probably have some indication, but definitely by April we'll know one way or another. And at that point, we will have, if we've determined that we need more people, we'll be looking at a way to have them and to reach out to get more people.
So is it safe to say if we gave you 8 weeks, you'll have definitive answers?
No, I can tell you by April whether what we're doing is working to the point where we're happy, and what I mean by that, satisfied with the fact that we're getting towards that 5-minute hold time. But I'll also know at that point, or I should know at that point, if in fact it's something where we need to maybe ramp up to more people as well.
Okay, thank you.
Commissioner Stevens?
I'd just like to remind everyone that Sunset Commission will be reviewing this very issue on March 15. Ever since I started serving, it's been 3 years. This issue already existed, so it's not a matter of hurrying up and trying to get there. I think that it's a matter of lack of willingness, because we have the resources, and we can't just be pointing fingers out at whoever is appointed next. Mr. Slagle is coming in, and then Mr. Hood is now coming in. I think that it all boils down to this commission. We have accepted this situation, and we have done absolutely nothing, and I think that it's up to us now, and they have not been able to solve it, and we better just make a decision of what is it going to take, because they were not able to do it. Now we as a commission, not they as a staff, and it's our job to direct this agency, and now we need to decide, if they couldn't do it, then it's up to us. And I think that we need to go back to perhaps put this issue on and ask Mr. Olmison to please go on probation, because somebody's got to be accountable and responsible for this, and he's the head of the agency. And I think it's time that we stop pointing fingers and just looking at the problem and our inability to solve it, and my suggestion is that we just do that. And that if we are not able to solve this by March 15, that, I don't know, that we decide on somebody else to head the agency, because we're failing to fulfill our mission to the public. If the public cannot reach us, how can we help them? How can we enforce these things? So that's my suggestion.
Mr. Slagle, just keep moving.
Okay. I did want to address a couple of other things. We are starting an audit process similar to the one that we started for the call center last June for the licensing division, to also look for possible ways to streamline and better make that that division more efficient. I wanted to address the license history. I know there's been some conversations about that since that went live in November. We implemented the free online license history for real estate on the real estate side. We've heard some issues with people who have searched for that and their initial license date was incorrect. I have been promised or told by the licensing department that the information that particular license, that the free license history provides, isn't any different than what we would have provided had they paid the $40. The issue, I think, comes from the fact that it's more readily available, so people who wouldn't have otherwise asked for it because they didn't need it for whatever reason are going on and checking. I've also been told that if due to the conversion from the system in the late 2000s, not into the 2010s, but that some of those records were changed, and that licensing has always had this policy that if people were able to provide documentation to show what their initial license date is, we're always willing to make that correction. So
I think the issue is with people like me who've been licensed a long darn time,
Yes,
and y'all don't go back that far.
Well, and we've heard lots of positive things about it. I will say that when we've heard license holders say, this state says they won't accept it, and then we reach out to that state, they say, oh yeah, and we have no problem with accepting it. With the exception of 2 states that want our staff to fill out their own forms, we haven't had any issues with any other states accepting this as a proof of getting licensed by reciprocity. But I did want to address that because I know there's been some concerns about that particular issue. And then just briefly, before I introduce Mr. Hood, I wanted to talk about a couple of things, just updates on things that I mentioned in my last update. Again, this is looking at a holistic approach, trying to address issues for why people call. And if we can reduce those issues, then they don't have to call, which also has an impact on the call center. The application tracker, which Amber's going to pull up a picture to show you. I know it's small, but if you look there, the front of the page, once this is implemented, the front of the web page is going to change, and you'll be able to click that second button that says check application status and type in a name and hit search applications. And then what's going to appear is, Amber, the next picture is something along the lines of this. It hasn't been finalized yet, but it'll be a checkbox system that'll show you where in the application you are, and then underneath it, I know it's difficult to see, there's an explanation of what each of those, the information that each of those documents provides. So that first one says documents received, and it explains what that means. So the thought here is that we get a lot of calls that say, where are you on my application? They'll be able to go online and not have to call to get that information, and if they see something on that they don't quite know, then when they do call, the call will be focused on that particular issue rather than just where is my application. So we're hoping to have that, we're still on target, I believe, to have that up and live by the end of February, beginning of March.
And could I ask, when that is running,
yes, sir,
successfully, will we then expand that program to include renewals?
Yes, sir.
Maybe some other thing.
So it's.
I'd like to see renewals. Have a renewal process where you can go online and check your renewal. Maybe a complaint process. So
that's
fielding calls all day long.
That's also in the hopper, if you will, a complaint portal. This was to deal with the largest number of applicants we have, which is sales agents. The next step is going to be to provide the same service for the largest number of applicants on the appraiser side, and then after that, we're trying to knock all the initial applicants out, so it'd be brokers and then back and forth, and then once we get all the initials out, we're going to look for ways to expand it beyond that. Good. But I will say to your issue, another thing that I apologize I've neglected to mention in my last update is we are moving towards having a display of CE on the website, needed CE. So if you're an applicant and you need to know what CE you need to complete in order to renew, we will now be able to display that.
You won't have to look at the calendar and do the math and...
No, sir. That's something we're working on getting that done. There's some processes in-house we're trying to get as well as, but that is one thing that we're working on to hopefully have up and displayed within the next couple of months. And I will definitely keep you updated on that.
That's wonderful.
Yes, ma'am. And then finally, I wanted to talk about the VO document upload. Both of components of that are unfortunately outside of our IT department. Our Versa, which is does our database of record, and then Nubis, which handles our document flow process. They've been working together to try to get a process in place by which people can upload their documents and they'll go into the right folder so that our staff can actually focus on how to process those. They're still working out some of the details with that, but we're hoping, if everything goes well, that we will have it in-house and be willing or be able to start testing it in about 5 weeks. And then hopefully that'll be up live. I guess that would be what, mid-April? Right. So, all right. That's all I have for my customer service stuff before I go on to introduce Mr. Hood. Does anyone have any other questions? All right. Thank you. Again, I want to introduce you to our new Director of Reception and Communications, but before I do that, I did want to publicly thank Amy Jasper, who was acting as the division director since Lori Dienda's retirement in early November. I do want to stress that her leadership was instrumental in making that contact center make sure it was operating smoothly during the transition, and that her ability to go into the weeds and recognize some of the things that we didn't already know about, i.e. the governor cap on the calls, and ask the right questions, helped us better understand some of the limitations of the software we were using. So I just wanted to publicly thank her for. Okay, it is my pleasure to introduce Robert Hood. Robert's been working in state government for almost 19 years. He started with TxDOT and was most recently employed with the comptroller managing their call center. He's a graduate of St. Edward's University with a bachelor's in organizational communications. He enjoys sports and is a member of the Austin Football Officiating Association and officiates high school, middle school, and Little League games. We're very happy to have Robert on the team. As I mentioned earlier, though he's only been here for about 18 days, his professionalism and experience has already had a positive impact on where we're going. Please join me in welcoming Robert Hood. That is all for me. Thank you.
Mr. Hood, appropriate that you have on a black and white striped tie then.
I'm sorry?
As a referee, you have on a black and white
Yes,
striped
that's right. Well, good evening, Madam Chair and Commissioners. I am Robert Hood, the Director of the Reception and Communication Services Division. Before I make my report on RCS, I would like to introduce two members that joined RCS team in December. Siobhan Martin previously worked in the contact center for the Texas Workforce Commission, where she assisted unemployed Texans for over 10 years. In just a few months' time, Siobhan has become to make a difference in RCS. She is handling at least 50 calls per day with little to no assistance at all. Eric Ortiz has been volunteering his time for the past 20 years with various nonprofit organizations. His past experience volunteering has made him a great fit in RCS and works very well with his coworkers and especially our customers. Please join me in welcoming Siobhan and Eric to the team. Since my start date of January 17th, I have been working hard to meet the goals set forth by the Commissioner and Deputy Commissioner. The following items have been addressed, and I will continue to monitor them. Number one, our staffing needs. I am very excited to announce that 5 new employees have started today in RCS. Please stand as I call your name. These employees are David Dickey, who joins us from the Texas Parks and Wildlife Department and has over 9 years of customer service experience. Courtney Scott joins us with 10 years of contact center experience from state and private sector. Elizabeth Ignacio joins the team with 4 years of experience from the contact center for the Texas Board of Nursing. Heather Robinson brings us experience from a contact center in the private sector as well. Lucy Roman has 4 years of experience in customer service and is fluent in Spanish. Please welcome all these new outstanding hires to RCS. In addition to these 5 new RCS employees, 3 more temporary employees will begin tomorrow on Tuesday. I will have 8 employees in training for the next 3 to 4 weeks. We anticipate an immediate impact to our hold times and abandoned call rate once these employees are taking calls. The second thing I'm focusing on is technology. We have met with the Department of Information Resources that manage our phone technology and expressed our needs to have more of the on-demand control of our precision queuing and moving agents around within the call queue. We will now be able to better adjust our manpower to meet the needs of our customers and utilize the phone system to its fullest. This is a relationship I plan to build on to assist meeting the goals set forth for the contact center. The third goal will be partnerships. One of the major things I've learned throughout my years in call centers is there is no need in reinventing the wheel. Contact centers have been around for some time now, and many have experienced the heartaches that we are going through today. It is very important to me that RCS team become a member of the Austin Contact Center Alliance. This membership gives us access to partners in the contact center industry that are feeling the same growing pains of Texas, and especially in the Austin area that we are today. We now have access to training materials for staff, peer-to-peer networking, portals to post job vacancies, and many more valuable tools. I plan on visiting and speaking with other contact centers to obtain ideas on improving the level of service we are providing. And also to address some of the questions you had before about how many staff do we actually need in order to get the job done. Right now, that is an unknown. I plan on diving in and trying to determine why are our customers calling? What are their needs? Is there any processes that we need to automate more? Anything we need to put on our website? Any hold music or any things we can put in our hold message that will be able to deter the customers to our website, or they'll be able to find their answers elsewhere. Now I'll report on the progress of our RCS team and our stats. On our C1 report for the month of December shows 14,711 calls were presented to RCS. 12,697 calls were handled by the RCS team. This was a 14% abandonment rate, which is higher than the preceding 3 months. The lower number of calls and the higher hold times and abandonment rate in December can be attributed to the adjustment made to the phone system in late November. The trend upwards continued through the month of January, which is historically a high call volume month. Good news is so far for the month of February, we are seeing some relief, and the abandoned call rate is hovering about 12%, and the average hold time is just over 9 minutes. 95% of the calls presented were for the commission, and a consistent 5% were for the board. For our walk-in customers, December was a slow month, and we assisted 156 customers in person. The lower number of walk-ins can be attributed to the holidays. Emails in December were not as heavy as the prior months. 2,818 emails were processed by the team. I'll be happy to answer any questions regarding the C1 report.
Madam Chair, I got a whole bunch of questions, but we can talk about it later when we go into setting our goals, et cetera. What item are the people excused for their...
After 19.
19, okay. Thank you.
All right, now moving on to the C2 report. For the month of December, 13 customers took the time to take our survey, and 8 of those customers left contact information. All 8 were contacted by our office and thanked for completing the survey. The top 3 items customers referenced in the surveys was our website content, customer service, and our processing time. If our recommendations are accepted, this is a report that will be revamped. I will be working with our staff to utilize our SurveyMonkey account and create a survey that will provide more beneficial information and give us a better idea of the level of service we are providing. I'll be happy to answer any questions about the C2 report. Now for the C3 report. This is a graphical representation of the first quarter of FY19. The average talk time for all calls was about 6 minutes, and the average hold time was about 10 minutes. Page 2 of the C3 report indicates the slight decline in hold time for the first quarter, then the spike in December due to eliminating the cap on the call queues. Again, if our recommendations for reports are accepted, this report data will be added to the C1 report. Any questions about the C3 report? Lastly, the C4 report shows the number of calls presented versus the number of calls on hold. Excuse me. The C4 report shows the number of calls presented versus number of calls handled and the number of calls abandoned. This is a graphical representation of the comparison of November to December, when the call volume was lower but abandon rate was higher due to removing the cap on the all queues. Any questions regarding the RCS reports?
Thank you, Mr. Hood.
Thank you for your time.
Welcome.
Thank you.
Ms. Jackson?
Good afternoon, Madam Chair and Commissioners. It's Gwen Jackson, Director of Education and Licensing Services. I'd like to take this opportunity to introduce to you a new hire in the LS division. Her name is Melissa Wyndham. She joined us on the 3rd of December as a license permit specialist in our division. Melissa comes to us from the Secretary of State's office, where she was employed as a customer service representative. She also has 6 years of experience as a license permit specialist 3 at the Texas Department of Motor Vehicles, where she reviewed and processed license applications and was co-author of a training manual posted on the DMV website. She enjoys running, and she participates in local marathons and other running events. Melissa's experience makes her easy to train, and in just a couple of months, she has made a positive impact on our workload. Please help me to welcome Melissa to our team. I'm also pleased to announce that we've hired 2 new license permit specialists who will be joining us on February 19th, and they will be introduced to you at the May Commission meeting. If all goes well, as of next Tuesday, ELS will be fully staffed. Please turn your attention to the L1 report. This report provides the June fiscal year-to-date totals and comparisons for applications received, licenses issued from applications, as well as renewal activity. The column to your far right provides the percentage of change for each line item, and you see that comparisons through the month of December reflect increases for each category. Renewal activity is found on the lower part of the page, and as of December, 20,431 brokers and sales agents renewed their licenses, or 86.5% of those who were eligible to renew did renew their license timely. If you have any questions regarding this report, I'd be happy to answer them. The next report in your packet is the L1A report. This report tracks the same information for the inspector program that the L1 does for brokers and sales agents. Here we see a reduction in total original applications received, or 131 fewer than last year this time, reflecting almost a 43% decrease. During this period, there were 519 inspector renewals, indicating that 67% of those who were eligible to renew did timely renew their license. Are there any questions for this report?
Yes, Ms. Jackson? Do we have any indication as to the particular reasons why the original applications on the inspectors have declined?
No.
To that degree?
To that degree? No, only that because the volume of inspectors that we have, as well as those whose applications we receive, because that volume is low, the percentages are low and appear to be expanded, if you will.
Thank you. Yes.
Ms. Jackson,
Yes.
It might be good to go to the providers themselves and that are educating these inspectors and find out. I would like to have that report sometime in the near future, if you can do that. Thank you.
Yes, ma'am. The next report is the L2. This report provides license holder and registrant totals. Basically, it's a snapshot of our totals for each month of the year for the past 13 months. To summarize, from December 2017 to December 2018, we've had little fluctuation on the total number of brokers, while the total number of sales agents increased by 4,361. Over the past year, our number of brokers and agents combined increased from 180,966 to 185,332. For a total increase of 4,366. The total number of inspectors and ERW registrants have remained relatively stable. With that being said, the last column and the last line item displays a total of 191,704 license holders and registrants for an overall increase of 4,658 since December 2017. If there are any questions on this report, happy to answer them. Right. The next report is the L3 report. This one provides a comparison of our fiscal year-to-date examination activity. The top portion of this report is for real estate examination activity, and the bottom half contains our inspector examination activity. If there are any questions on this report, I'd be happy to answer them. The next report, the last report, is the L4, which provides for us the number of approved instructors for real estate and inspector courses. Totals as of December are reflected in the far right column. And this concludes the ELS reports, and I'd be happy to answer any questions you may have.
I just have one comment, which with regard to the L1A report. I mean, anytime, Ms. Jackson, there's a dramatic decline or increase in applications received for any of the professions that we oversee, we would love to hear your best conjecture as to why it included in your report. So just for future reference. Thank you.
Will do. Thank you.
Great. Thank you, Ms. Jackson. Mr. Moore?
Mark Moore, Standards and Enforcement Services. Before I start the reports, I have a couple preliminary matters. First, we have Becky Combs, who I hope is standing. She is a new attorney with the division. She started on December 17th. She comes to us from private practice, where she practiced real estate law and administrative law. She'd also been an enforcement attorney for the Texas Commission on Environmental Quality, and she also, for a couple of years, was a real estate agent. So she has a real strong background for our type of cases. Thank you.
Great.
Becky. All right. Glenn Killey, who I hope is also standing up, started with us on February 5th as an investigator. Mr. Killey actually made a living working as a real estate agent, which I understand is a challenging business at times. I've certainly learned that over the years. He's also a proprietary school instructor as well. Obviously, he can't do either of those things while he's working at the commission. And most recently, he worked at CASA, which is a pretty reputable child advocates group.
That's right.
That's right. And one more thing before I start my three reports. After I finish, Beverly Rabenberg will give her annual report on the timeshare program and the resident service company program. I'm saying that now because I have a tendency to walk off out of habit. So she will be speaking immediately after me on, and those, you have materials on that. Okay. Our three reports, our first report is the case status report, and mostly what I focus on when I speak with you all is the numbers in bold, received during month, closed during month. December was slightly lighter, as it often is during the holidays, but the good news, if you scroll a little bit down, please, Amber, we have closed more cases during the year than we've opened, so that helps some on backlog issues. And that's also reflected if you look at the next report, the open case aging report. We have 96% of our cases are less than a year old, and that number's been pretty steady, 96% or 97% for about the last year or two. We had, on this report, we have 11 cases that were listed as over 2 years old. One of those got resolved earlier today, and the other 10 were actually a series of related unlicensed activity cases, and they settled right before a hearing, I think, a few weeks ago. So none of those cases are live anymore. The third report is, of course, the pie chart, which is the complaint subject categories report, which shows the general subjects of cases, real estate cases that the Enforcement Division handles. And then the final page is the raw data, which will fluctuate some month to month, but overall will give us some idea of the volume and the percentage of cases, types of cases we handle. Do you all have any questions on that report or any of the others?
When you mentioned with one of the cases that we went over that advertising complaints are not that common, but I guess that stirred my curiosity. When they are filed, is it consumers complaining, which this one was, or is it other agents turning in other agents?
It's probably, it depends on the type of case, but it's more common. We see a lot of license holder disputes on advertising, and we see a lot of technical violations, which are important. That's why the Commission passed rules on them. But those are the most common ones. It's rare to, what I referred to before, it's rare to see a misleading advertising case that goes to a hearing and comes before the Commission. I'm not aware of any others.
Thank you.
All right.
Thank you, Mr. Moore. Ms. Rabenberg?
Somebody talk.
Tony?
Good afternoon, Madam Chair and Commission members. I'm Beverly Rabenberg, one of the attorneys with Standards and Enforcement Services and the program manager for the Commission's timeshare program. In addition to myself, there is one other attorney and a legal assistant that spend a portion of their time on this program. There is a short report on the timeshare program that has been included in your materials on page 205. The statute in this case that the Commission regulates under is called the Texas Timeshare Act, found in the Texas Property Code. In Texas, timeshare has been regulated since 1985, with the last major statutory update in 2006. There are two big consumer protections in this statute. One of them is that the consumer actually gets a 5-day cancellation right. Sometimes we hear in real estate deals, it's like, don't I have a 72-hour cooling off period when I'm buying a house? Answer, no. But for timeshare, there actually is a 5-day period. The other thing that's important in timeshare transactions is that the consumer gets a disclosure statement with a lot of information about what they're purchasing. What the Commission does is we register timeshare plans. It's kind of like licensing them. I think of it as like a permit to sell. The registration from the Commission is required if the company wants to sell or offer to sell a timeshare interest to a Texas consumer, and it covers the sale of developer inventory, basically sold to a first-time consumer. In looking at the statistics on page 205, we actually saw a small uptick in the number of complaints, in the number of new registration applications in 2008, going from 9 to 12. Timeshare is very dependent on how the economy is doing. If the economy's crashed, nobody's buying, going on vacation, and we went months without a single registration application back in the day. And now we've gone up to 12. Most of those are new projects, and a lot of them are upper tier. They're the nicer stuff that's kind of fancy. The complaint numbers have decreased significantly during the last fiscal year because most of what we had been getting were form letter complaints that weren't necessarily legitimate complaints, but we had to process them anyway. Basically, it was a form letter, and it's like, I bought, and it had the exact same language in it, and had been churned by a law firm or something called an exit company. And those pretty much turned out to be, there just wasn't violations there that we could find, that we could be able to prove. The people really wanted their money back. They wanted to cancel, and it's like, that isn't anything the Commission can do to help you. We have authority under the statute to take disciplinary action against the developer, not that we can, get you out of your contract or give you back your money. There have been no complaints that resulted in a disciplinary action since my last report to you in November of 2017. Our ability to take disciplinary action is limited and is very different from the jurisdiction we have over sales agents and brokers, where it's an individual and it's their livelihood. In these cases, we're talking big companies, and this is what they do, and taking disciplinary action is very limited. Any questions on the timeshare program before I move on?
Yeah, I've just got a couple out of curiosity. I mean, this is historically sort of an industry that's associated with boiler room type, sales practices and things like that. So I'm just curious on kind of the character of the activity in general you see in Texas among timeshares and the character, I would say, of it. And then secondly, I'm curious if any of these complaints, or we've received any complaints of unlicensed sales, people doing this without registering with the Commission.
Okay. The character of Texas activities taking place in Texas, there are some developers selling here. A great majority of what we register in the transactions are actually people that just wanted to solicit Texas purchasers. Come visit Orlando, come do this, and so, but there are some here in Texas, and those are the ones, when we do get complaints, we look at.
So for the ones soliciting in Texas, how do we regulate that? How are we resolving complaints and issues?
The solicitations themselves, there are some mandated information that has to be in the disclosures, and I haven't had a question or an inquiry about that kind of thing in lots of years. It's not anywhere that ends up on anybody's radar. What was your originally your second point?
The second question was just regarding, people not registering and, yeah.
Okay. Well, there's two different things to look at. There's the registration of the timeshare plan. I can't remember last time I saw anything like that. They pretty much want to be regulated, and I think our regulation is reasonable. There's the question about the actual sales agents. For the most part, they're employees of the developer and exempt from the licensure if it is a real property interest. In many cases, there may be clubs or a right to use kind of thing, so there's no license required, and for the ones it may be a real estate interest, it's our understanding they're employees of the developer and they're exempt for sales in Texas.
Madam Chairman, it just does occur to me that since the legislature hasn't looked at this since 2006, that we might ought to prod somebody there to take a look at the Timeshare Act. Thank you.
Well, and if I could just quickly relate, the 2006 amendments were basically a major update that was actually pursued and pushed by the industry to bring us more into the modern age. There was a lot of things in the statute that didn't make a lot of sense that were from 1985, and the changes were very good changes from back then, and there may be been a few little tweaks, but it's pretty much held up, which is amazing to me sometimes. So, anything else on timeshare? Okay, I'll move on to the RSC program. I'm also manager for this program. If you go to page 206 in your materials, there's another short report. We use the acronym and call these the RSCs, or some people call them as home warranties. Well, they aren't quite a warranty, they are what they are, so that's what terminology people tend to understand. We regulate these under the Residential Service Company Act, which is found in the Texas Occupations Code. I myself am the attorney on the program. There's another attorney, and we have another legal assistant who helps us with this. We license the companies that want to sell residential service contracts in Texas. Commission approves their contracts, and we may approve their rates, depending on how they have their structure set up. As you can see from the information on the bottom of page 206, the number of companies that has stayed roughly steady, around 50, as have the number of licensure applications. We had a couple companies finish their applications. We actually did license 2 new companies in about the last 2 weeks. So that number's actually crept up already. There are also the applications to approve their contracts and their rates, which rose from 155 in fiscal year 2017 to 178 in fiscal year 2018. What makes the RSC program somewhat special or unique is that there is an ombudsman we have for this program. That's our legal assistant, Donna Englert, who answers a phone line dedicated to residential service company calls, primarily complaints. That's the 512-936-3049, and that number is also available on our website. Part of our consumer protection mandate is that phone number, along with other information about the commission and how to file a complaint, is required by the rules in every single contract that is issued to a Texas consumer. Another thing available on our website is a list of all 52 companies that are currently licensed. So if people get a solicitation, like, are these guys legit or whatever, they can actually go look them up and see, and those are on our website. Calls handled by the Ombudsman in calendar 2018 ranged between 11 and 29 per month, with 225 calls for the entire year. Some people call our RSC line or just get through to us on the Standards and Enforcement Services line because they have an immediate problem. The Ombudsman works directly with her contact at the company to try to get things worked out informally and resolve a problem quickly. When it's cold and you don't have any heat, it's important that you get something done now. Donna may also help a contract holder better understand the contract and why something isn't covered. And companies can't cover everything, and a lot of people need to, it helps if they read the contract and we can explain it to them sometimes. Some people just want to talk to somebody before they file a complaint, which we do a lot of that too. Complaints were up a little bit in fiscal year 2018, increasing from 104 to 139, but they're still a very small percentage of all the complaints received by Standards and Enforcement Services. We've had no major cases for disciplinary action since the last time we reported to you in November of 2017. That's the end of my report. Are there any questions on the RSC program?
Commissioner Miller.
Ombudsman receives calls, and I thought you said 225
For the year.
for the year. Okay, so this report's 139, so if they don't
Those are complaints.
tell the violation,
That's the actual number of complaints that are filed. That's the signed, written, formal complaints.
talks a lot of people off the list.
Yeah, I think that's a good way to put it, yes.
Any other questions for Ms. Ravenberg? Thank you.
Great, thank you.
Mr. Rapp. Appreciate the staff hiring someone else named Steve so we don't have to learn a new name.
That was one of the criteria. Good afternoon, Madam Chair and Commission members. My name is Steve Rapp. I'm the ITS Director for the Texas Real Estate Commission, and it is my pleasure to be standing before you here today.
Thank you.
Before I get into the I-1 and I-2 reports, which you're used to seeing, I'd like to circle back at a previous commission meeting. It was reported that the ITS team was actively recruiting and interviewing 3 contractors to help with the long list of IT projects that we have going on. Happy to report today that we have filled all 3 of those positions, and that those 3 individuals are either actively working on high priority projects or they're working on internal projects which alleviate valuable internal resources to focus on those high priority projects. If we can look at the I-1 report, please.
Okay.
Turning to the I-1 report, this report details website and online transaction activity for December 2018 and for the calendar year 2018. A little bit of good news at the top. Web utilization continues to rise, is better for the month and better for the year overall, which is where we hope our folks go. Looking at the initial applications, those statistics remain flat at around 81%, which is higher than the previous 4 months. However, we did see a noticeable drop for the fiscal year, over fiscal year 2017. Online renewals continue at 95% or better, and we see an upward trend over the previous fiscal year. Do you have any questions on this report?
Mr. Iaga?
Yes, sir. Been on board for how long?
3 days longer than Robert. So I'm no longer the rookie.
Welcome.
Thank you. Thank you.
What was your first big shock that you saw when you walked in regarding our hardware and software?
I don't know that there was a shock. I did a lot of research before coming into this position. I watched Sunset Commission meetings. I watched previous commission meetings. And so I was pretty aware of where we stood and what needs to be done here. So I don't know, when you say shock, nothing comes to mind.
Because everybody I talked to is years ago, 2-3 years ago, I never had a problem calling in. And so it's either IT or telephone systems, and something happened. It's not the culture, because people are not asleep. So something is happening with technology, and I'm told technology can solve everything now.
Technology can certainly partner with everyone in this room. I have been impressed with the leadership's response to the issues that are going on. I've been impressed with Mr. Hood, who disappeared. I just went to point to him. I've been impressed with some of the changes that he's willing to make. And ITS, we have the privilege, I guess, and maybe the unenviable task of helping support all of those initiatives. We can't fix everything, but we can certainly support the strong efforts that are being made by this agency.
Sunset accuses us of having a broke system. Says we need to fire people, or they would have fired people if they had that kind of response. Okay. And Commissioner Bob is correct. Five minutes is still way too much, but still we're not there. We're not even. So something is going to have to happen. And I saw the list of 1.3 million, how it's going to be spent. I don't understand it, so we're going to trust you that we're going to spend it the correct way. All I know is another agency I came down from was a $5.4 billion agency, and when we got a new software and hardware system, it still didn't work.
What I can say towards that is that IT, while supporting the immediate problem with Director Hood's Communications Division, we are also focused with what Mr. Slagle has said are the root cause of the problems. And I think that's where IT can provide the biggest benefit. Providing applications is keeping those calls from coming in. If we can provide that information in 1, 2, or 3 clicks, and develop those habits by our licensees to go look at our website or other means to find that information, then the solution snowballs. And
our future hangs in your hands, and someone mentioned that not only is staff going to be fired, but the board's going to be fired if we don't correct things real quickly. So help.
I can't speak to the firings. I can speak to, I've liked what I've learned since I've gotten here. In my opinion, it's a strong leadership team, and I inherited a very strong IT team. And so I think we're going to do great things in 2019.
Thank you.
Let me ask you a question. It's a simple one, maybe 2.
Oh, go ahead.
Are we controlling the technology controlling us?
Well, that's a great question. There is technology that we have full control over that, for instance, our internal architecture, we have more control over that. As you well know, our system of record is the Versa licensing system. We have less control over that. But where we can't get that system to do what we want, we've become very adept at creating that solution outside of it and interacting with that system. And we'll continue to do so until there's another system of record.
Well, we want to help in any way because, it's an ever-moving target, and I commend you, and we really appreciate you being on board. But really put us in position to help you as soon as possible.
Okay. I appreciate that. Thank you.
Commissioner Leonard?
If I can ask Commissioner Arriaga's question in a different way, what would shock us?
What would shock you?
And let me follow up, and I
don't know that I have a good answer for that.
I hope we didn't scare Mr. Hood off.
To find out.
Understand that
I sent him on a mission to research some data for me.
we're here to make all of this work for you, for him. So we're not trying to be the bad guys here. We want you guys, you and Mr. Hood are at the precipice of being heroes if this works out. So you need to let us know. Don't be bashful. Let us know what resource we've got. The resources. Let us know what you need to make this work.
I appreciate that.
Okay, and tell him when you see him.
I will do that.
Okay.
Any other questions on the I-1? Yes,
I
ma'am.
appreciate that you took the time to listen to Sunset Commission meetings.
Yes.
And that you have actually watched the commission meetings as well. Thank you.
Well, I wouldn't be here if I didn't get answers in my interview that I found acceptable and encouraging. You're welcome. I think I still have one more report to go.
Yes, you do.
All right. Moving on to the I-2 report. The I-2 report is a graphical representation of the previous report. It shows you 13 months worth of data so that you can see 2 things, what our statistics have looked like over the calendar year and how they compare from December of 18 all the way back to December of 17. Do you have any questions on the I-2 report?
Why the, Madam Chair?
Yeah.
Bottom chart, why the dip in February? You weren't here then, but if you have to guess.
The dip in February on the utilization management tool?
Yes, sir.
I don't have an answer on that one. I can find one and report that back to you.
Typically, when you see any dip like that at all, it's because of a merger between firms. So if you have 2 large brokerages, this has happened several times, like once a year, for the past 5 years or something. There'll be a significant blip because one brokerage with 400 merges with another one with 800, and we need to move a whole bunch of folks, and they just send it all in on paper rather than sit there and do them individually online. So we get a giant box of transfer forms. And so this is the if you did it one by one, as we do 1,000 plus a week online, then they're typically just one-offs. But occasionally we'll get one of these large merger firms and they'll send us a giant box of them on paper.
Interesting.
Any other questions?
Good.
All right. Thank you.
Thanks, sir. Ms. Pifo?
Madam Chair, Commissioners, good afternoon. I'm Priscilla Pipo. I'm the Director of Staff and Support Services. Before I get started, I first want to commend my staff for the hard work that they've done while all the hiring and all the contracting and all the temporaries and all the changes that we've been making. They've done a phenomenal job. And I'd like to introduce you to the newest member of our staff. Her name is Bernetta Talbert. Thank you. She is our voucher accountant. Bernetta comes to us. Sorry, my timing was off. Our voucher accountant, she replaces Elena Rand. She comes to us with over 25 years of professional accounting experience managing vendors and supplier relations, working in accounts payable for the state of Texas at both the Lottery Commission and the Office of the Attorney General. She has worked in the private sector and attended Texas Southern University in Houston. She's already an indispensable member of the accounting team. She's got a deep level of experience and a spirit of teamwork. She's pitched in and helped in all kinds of ways. We're very grateful to have her. Please. Thank you. I'd like to bring your attention to my first report, the budget status report for the end of December, the fourth month of the fiscal year, presented to you for your review. You will note our expected remaining budget should be at 66.6%. 67%. According to the amended budget policy, when we have a variance of greater than 20%, we will provide an explanation. All of the variances have notes next to them. They're based typically on single events that have occurred throughout the year, and we've noted that as it should be. If you have any questions about that, I'd be happy to answer them. Overall, we're a little bit less than we budgeted for expenditures, a little bit higher for revenue. If no questions, I'll move along to the next. I'll turn to our investment reports. The first one is the S1A report. We had one investment mature in December, which was reinvested and had an ending market value of $14,472,573. An ending balance available for operations of $5.5 million. The S2 report, our next report, the Real Estate Recovery Trust account, has an investment mature also, which was reinvested. We list for you on this report the receipts for the current month, along with disbursements, making it a little bit easier to follow how much is coming in and going out of the recovery fund. You'll notice that on the amount that's reserved for future payments coincides with the amount on the next page. If we'll move now to S3 report, which is a report of the activity over the past year of recovery fund payments, with the potential payments for the next 3 months of $520,500. If no questions, we'll move on to the next report, please. The next investment report is the S4 report for the Inspectors Recovery Trust Fund. You will note that there have been no payments made in 2018 or so far in 2019. And as you will recall, we will forward any remaining balance at the end exceeding $600,000 at the end of the calendar year to the state's General Revenue Fund, which will be reflected in the January S4 report. Any questions on investment reports? If not, let's move to the next report. This is our new look for our true-up report, which we will be presenting in November. We wanted to give you a picture of what you actually approved in August and give you a true-up of that report rather than through the budget status report. So it shows you all of the years of expenditures and revenue, as well as gives you an idea of what the true-up is. So the amount of actual expenditures you'll see in the 2018 actual expenditures column. And you can compare that to the budgeted expenditures, which is not a whole lot different. And then it's less, and then the revenue, of course. But the second page of this report gives you a little bit more insight into the reserves, and I know it's very detailed. The main thing that you'll want to note is that we have trued up all the cash and all the available data that we've got at a point in time. Sorry, it's small for me to look at. But you'll notice the reserve for contingencies and operations is $4.4 million, and that falls within the approved range that you set with the investment report back in November, between 30 and 40%, which is, it's just below the 40% cap. And then I would also bring you down and show you under the Education Development Reserve, reallocation from the balance of the Education Reserve, because you chose to vote that would be ended, and so we have transferred that reserve out of the reserves. So again, this is just a recap of what we went over in November in a little bit different format. We will continue to provide this year over year. If there are no questions, I will move along to the proposed budget amendment. Please.
Madam Chair?
Questions?
Yes, ma'am. On the colorful page 1, I guess, on the budget.
Yes, sir.
Halfway down, communication services, or is it supplies and equipment? Can't get that close. It was recategorized and moved up to professional fees.
Yes. So sometimes one of the things we struggle with at the state is when we have very specific accounting codes which we must follow. Professional services and contracted services and communication services all tend to be a little bit close together. So occasionally we'll budget one up and we'll think it's in this category, and when it comes time to expend it, we'll need to move it down into another category.
Yes, but you're not moving the little cups around so we don't see where the little P is, right?
No. Not at all. No, our accountability is to the comptroller when they come out and begin to audit. When we will have a post-payment audit, one of the things that we will have to account for is that we have used the exact right expenditure codes. And so it's sometimes a matter of interpretation on the part of staff to determine that.
I guess next is going to be the amendment, so we're going to change
sir.
the, okay.
The next thing that I would like to present to you is the budget amendment. So you have 2 pages in front of you. The first one that Amber has brought up, thank you, is the Technology Reserve Project, and that is on page 217 in your materials. So what Mr. Rapp was talked about just a minute ago is hiring these temporary staff members. That is on this report. So this report of the Technology Reserve Project costs gives you the fund balance, the amount that we've expended in the period, and then some encumbered amounts, which show under the encumbered amounts, we're showing the IT staff that we've reported we have engaged. That gives you a total expenditure amount of $302,041, which leaves a remaining balance in the Technology Reserve of $997,959. The budget amendment, then, if I can turn your attention to that, takes that $302,041 and it breaks it down by the by the expenditure categories in green. So you'll notice the lines under professional fees and services, the first line from across, temporary ITS, if you'll notice the comment on the right-hand side, temporary ITS staffing services, for $274,000 for contracted programmers. That coincides with that previous page I just showed you. The second line, maintenance and repairs, shows you it's amended to add $7,425 for JIRA service desk licenses. Those licenses will be used for those contractors and for others. And then under supplies and equipment, if you'll notice in the comment, amended to be $19,879 for monitors and laptops. So that expenditure totals down to $302,041. This will be the new way in which we bring forward from the Technology Reserve to account for the expenditures as we put them into the operating budget, into the operating expenditure categories that we're required to use, and that we bring this to you for your ratification. Any questions about that portion? There are two portions of this amendment.
Got
Yes,
one
sir.
question. The 1.3 million that we're reapportioning, none of that goes toward personnel except for new personnel being brought in to help us with a call center. Is that correct?
IT.
So this is, can you rephrase your question,
Yes.
please?
This money is to solve our problem on response times and hang-up calls.
I understand your question, I believe. The technology reserve that we set aside is to use technology, as Commissioner Williams mentioned earlier, to solve these customer service problems. So right now, the contracted staff I put before you are actually developers who are being brought in to create some of these projects that they've been talking about, like applications online where they can download their documents. So these are the technology expenditures to solve the customer service problems.
But no staff monies or to offset staff costs.
Not in this particular
Not in
bucket.
this, okay.
Yes,
Because
sir.
we gave away some bonuses at the end of the year, or beginning of the year, I guess.
Beginning of the year, yes, sir.
And that's the only time we enhance salaries for anybody.
So far. So we're only halfway through the fiscal year, and our compensation policy allows for an equity adjustment at the beginning of the year, and then merit raises halfway through the year, and we're there.
I was not aware of that.
Yes, sir. I have that information. Actually, I have a copy of the compensation policy, if that would be helpful.
And that money is already budgeted.
Yes, sir. That's in the approved budget that you approved in August.
Will not come from the reserves.
No, sir.
Okay, thank you.
Any further questions? Sir.
There's just one more item on the true-up
Yes,
for
sir.
the license fees, if
The
you want to
revenue.
explain that.
Yes, sir.
Okay.
So down under revenue, you'll notice that there's a comment. We've corrected prior adjustments for sponsorship fees and license history reduction to the tune of $125,000. That's just adjusting the revenue. So those are the two items within this budget amendment, which you'll be asked to vote on later, and I believe it's agenda item number 23.
Ms. Pifa?
Yes.
I have a question. Would you please tell us, we received an email that the agency is it's undergoing an audit by the state auditor's
Oh, good.
office.
Yes.
Can you tell us what that entails?
Yes, that was one of the comments I was about to make, but I'll go ahead and make it now. The State Auditor's Office, in fact, the next report in front of you is statistics from the State Auditor's Office, if Amber will bring that up, which they do biennially for the legislature. And this report gives you a snapshot, which they do for all state agencies, about the workforce summary. The date is at the end of the year of August, and it reflects actual positions. If you'll note that TREC tends to have a steady staffing, low turnover compared to other state agencies, and specifically with other similar agencies, and above average compensation. The statistics that they reflect are consistent with the annual compensation study that we do with the salary review every year to ensure that we're competitive. And my final note is to Commissioner Stevens' question. We are being audited now by the State Auditor's Office. It's something that they do periodically. Typically with SDSI agencies, it's about every 4 years. And they come out and look at our typically financial controls and policies that result. The audit report will come out. It will be presented in July. So they're doing their field work right now. And we have budgeted for that over time so that we are prepared for that expense. And I don't think I have anything else to add. Are there any further questions?
Yes. Commissioner Wilkinson?
I just want to thank you. You give the best reports, so they're very clear, very precise, and very understandable.
Thank
We
you.
appreciate that.
Madam Chair?
Yes, sir.
Under employee turnover and compensation, I can see that we're above the state average in compensation. And when you look at the turnover, I guess the light blue, when people leave, Is salary a problem still, or have we turned that corner?
I think we've turned that corner with regards to the most recent salary study that we have done. One of the things I was texting one of my staff members during this time was to find out the RCS staff turnover, which I'll be able to report to you later in the game. But the call center turnover tends to be particularly high in all agencies, and I will tell you that's the first question that I asked Mr. Hood when he came on board, that just tends to be one of those revolving doors. So the challenge is getting them trained, getting them on the phones, and meeting those challenges as they come on. But
So why are people leaving?
I think that we are, again, it's a good question, and I think it depends on the person at the time. But I think we're also making really good hiring decisions right now. And some of the people that we are bringing in, we're really fortunate to have. We are seeing some changes that will, I think part of what you've seen in those numbers, the ripple effect of some retirements. We've had a lot of turnover all of a sudden that will make your numbers dip. But I'm confident that these numbers will go back up because we have some good programs in place.
Thank you.
Commissioner, if I might, one of the things you'll notice is, as Ms. Pifo said, we're making better hiring decisions. One of the things that Mr. Hood, when he introduced all the new members, one of the things that was most striking to me is every single one of them had previous contact center experience. That's the largest tell for whether or not someone's going to be able to remain. So out of the pool of folks that we have an application from, we have hired in the past people who are willing to give it a try. But to have people who've moved from one contact center to another to come to ours, even knowing the volume that we have and the fact that we've increased the pay and benefits and the training, we're actually attracting people from other contact centers, which is what we've needed to do. And as I think he said, and others have noticed, we've kind of turned a corner there.
Just brief, quick follow-up on that point. Are most of these people continuously employed at call centers and then they're coming to work for us? Or is this something that they've been in before, then they've done something else, and now they're back?
So of the last group of 5 that were just, there were 3 that came directly from other call centers. 2 had other call center experience in their back.
Thank you.
Very good, thank you.
Thank you.
Thank you.
Anybody else making a report that I don't know about?
No, ma'am.
Agenda item 10 is the Executive Committee report. Commissioners Turner, Arriaga, and I had a Executive Committee meeting by teleconference on January the 11th. That agenda is on page 225 of this meeting materials. And we also had one on January the 8th. And we had one last week. Is that right? Is that only 2, though?
Yes.
With a joint executive committee meeting with the appraisal board. And in all cases, we were primarily discussing the things that we are going to discuss later on today regarding our staff's responses to the Sunset Commission and our staff's actions taken that need to bring us, that are targeted towards bringing us into compliance with what the Sunset Commission is requiring. We're pretty much going to go over everything we've gone over. We received the information about the retirement of general counsel and all of those things as well, which you have also received. Mr. Arriaga, you think of anything else we did?
Yes, everything is about performance and trying to determine how we put our arms around that in order to, a year from now, not have the same problem. Yep. And we go back to the same thing. And the 5-minute rule actually came from Chair Avis and has always emphasized that. And it's still a mystery to people like me, why all of a sudden did we become inferior in being able to answer to calls when that problem was not there. And like people back home tell me, is Arriaga, we'll pay extra if you just pick up the phone.
Yep.
Thank you.
Thank you, Mr. Arriaga, for bringing them up to speed. The Enforcement Committee has several things that we're going to look at later on, and TJ's not here. Mr. Leonard, Mr. Arriaga, you want to kind of tell us what we have coming up from your meetings?
Kristen?
Kristen, who's going to talk about the Enforcement Committee?
Sure, Madam Chair and Commissioners. The Enforcement Committee does have several proposals that will be considered by you later in the agenda to implement the Sunset Commission recommendations. And that's the primary issues that the Enforcement Committee discussed at its meeting on January 8th. So we'll be talking about them.
Okay. Any questions? Agenda item 12 is a report by the Education Standards Advisory Committee. They did have a meeting. They have a whole bunch of new people. They did some good stuff. They elected a chairman, a guy from Houston named Rob Cook, and he couldn't be here today. And you're going to just we got stuff we're going to look at later in the agenda also, right?
Right. No, actually, he couldn't be here today and sends his regrets. And they talked about several items to move forward to the commission. But subsequent to that recommendation, they got a request to look at it again. So what they had been working on will probably come before the commission in May.
Okay.
Madam Chair.
Yes.
This is related to the ESAC meeting. At the last meeting,
okay,
at the last commission meeting, we voted that the calculation for, there was a very difficult calculation for people in the industry to come up with, and this commission voted on it, and we said that we were going to bring it up during the ESAC meeting. And what are we going to do about that? I read an email that this agency, during the time that it was communicated at the ESAC meeting, that it was somewhat inappropriate, and I am concerned about the culture. It was a, can you please tell us what we are doing about that? I think that someone in the agency spoke regarding Champions Real Estate School, which was the school that stood up to tell us that we had a problem, and we looked at it during the last meeting, and I think that we owe it to some of the people who still have concerns out there to tell them what we're going to do about it, because we did not, I don't think that it was handled appropriately. So do we have a plan? Thank you.
Commissioner Wilkinson, I was not in the meeting. You were at the meeting?
Yes, and Rob Cook, who is the new chair of ESAC, he has told Miss Santa Maria that she can attend the next meeting, and so that, as far as I know, that's the way it's going to be, correct?
Right, and that's what I was saying. They did look at what you sent back to them. The ESAC committee did. They did some trial calculations. They made a suggestion for a minor change to the rule that had to do with where you put the decimal point, so so that it would not be confusing, because they thought that was one area that was confusing, but the rest of the calculation, they thought when you follow it through step by step was good. Since that time, one of the largest providers asked if we could hold off and not present it to the commission, because she wanted to go back and further explain. She was not there. She had two staff members there who didn't speak up, but she wanted to come explain more of what her problem was, and the chair, Mr. Cook, has said, yes, we will wait to present our recommendation to the commission till after you come to our April meeting. So this will be before the commission in May, after the provider has a chance to go into more detail about what her concerns are.
Thank you.
Okay.
Madam Chair. Okay. I have concerns about, I think that this is just to caution every one of us who participates and who serves as commission members, and anyone in staff, to please be very thoughtful when we express our opinions and when we're speaking on behalf of the agency particularly, because it reflects the culture of this agency. And we are not just, when we are out there, we are putting out everything. And my concern is this occurred just about 3 weeks after we had been pretty much reprimanded by the Sunset Commission. And this just shows total, probably, perhaps disregard, or perhaps, I don't know what it was, but it's just unacceptable. I listened to the comment that were made, and I think that we need to be, I'm very concerned. I really think that this agency needs to really think about culture and what we're portraying to everyone else, because not just, this is like a continuation of the call center. We need to show, do we value the people whom we serve? And we need to show it with actions, not just with words, and our actions show otherwise.
Yes.
I agree with you. I think the key thing here is for us all to remember, there is not anyone in this room, anyone on the commission, I don't think anyone has anything but we've all got the same goals. We all want to get to the same place. And we know we've got problems, and it's been acknowledged. I think the key thing is we've got to be very, very sensitive to each other and how we handle our words and where they're spoken.
Okay. Thank you.
If I may, Madam Chair, just if it's all the same to everybody, I think we all agree we've got problems. So for the remainder of the meeting, if we could kind of suspend platitudes and focus on the agenda, I think that's the best thing to do.
Thank you. Agenda item 13, the Broker Responsibility Working Group. Mr. Jones.
Thank you, Madam Chair and Commissioners. You can see the blank page before you. This is part of a change you made during your November meeting, that instead of doing a report, we provided you with our minutes from the meeting, and I'm here as a resource to explain any of those or to point out any that I think are significantly important. I won't steal the thunder from the inspectors. They have an issue they brought before us that during our discussions, as it turned out, pay for play, that's kind of a poor way to describe it, but there's a systemic problem that by all indication is much more prevalent in the inspectors having to pay to present their wares or present their goods to their potential customers, is a problem not just founded in North Texas, but certainly all throughout real estate. And of course, we've had to fight the P53 issue, which was a similar battle. I'm here to answer any questions you may have about that. This was an extensive part of our meeting, talking about examples and issues, and what General Counsel gave us a great definition of how limited the enforcement part is, or the jurisdictional part of the commission as opposed to RESPA and the federal laws, those kind of things. The other part that I think is worthy of a mention is that we continue to work on the IBS explanation of services provided or potentially provided. We have reached out and asked to partner with the Texas Association of Realtors. We've not gotten anything back from them, but we certainly look forward to any input they can share with us, and that's mentioned in these minutes, of course. Again, I'm here to answer questions. Thank you for this group. This is you've identified an incredible working group. Their product seems to be, I said earlier, almost like magic. I personally thank you for allowing me to do this, and speaking for them, the ability for them to participate and contribute in this way.
Any questions for Mr. Jones? Mike?
Yeah, your partnership, you say you reached out. Did they ever give you an answer, or where are you guys in that process?
Not yet, and what we're speculating, if I can use that word, what we're speculating is that this would be some kind of form that they could use explaining the services provided either for a listing side of a transaction or a selling side of a transaction. And certainly there's some middle ground in there that would have some other issues. I do property management, and there could well be some definitions in that. In the speculation, we kind of molded a thought that said this might look like a listing agreement or a buyer rep agreement in a very light fashion, saying here's the list of what we do. We think this is historically, since the IBS came out in the 90s, we think this has always been a little bit of a contentious issue to try to address or answer. If someone wants to misunderstand it, certainly they will misunderstand it. And we think there's a need, or at least a calling, for some clarity in this form. We think it serves the purpose well until you get to those types of questions. Well, what does it mean? What are you doing? What are you not doing? Whatever. Did I get close with your request?
I think so.
Okay, I was trying.
Yeah, and if I may, Mr. Jones,
By all means.
you're referring to minimum services in a form that would be similar to the IBS, not the IBS.
Sorry, absolutely. We're not drilling down into these specific things that could be voluminous, but certainly a minimum services clarity to the current iteration that we use daily.
Thank you,
Thank
Mr.
you.
Oh, wait, Mr. Miller.
I just wanted to ask a question for clarification. For the reason we now get minutes ahead is just so we know more about what you all discuss, and we're not just hit with it when you come to tell us. But I certainly enjoy the summary that you give us every time, and that you can tell us what you really, these are the items we really want you to act on. But to have us have the background, to me, is very important.
And I renew my invitation with great respect to the Open Meetings Act that Commissioner Arriaga came to our last meeting. We invite you, limited numbers, mind you, to come watch this and participate. He participated. We benefited from that. And you bring an element that we wouldn't otherwise have.
I think it's a good group. Do good work.
I'm sure it is.
Thank you, Mr. Jones.
It's an interesting group. I don't think any of them get along outside of this venue, but when they're together, it's just great. Thanks for letting me do this.
Thank you. Agenda item 14, Ms. Warren, Chairman Warren, you coming up to make a report?
Good afternoon, Commissioners. My name is Lee Warren. The Inspector Committee has met twice since the last time the Commissioners met, once in December, once again it's in February. At that meeting, the committee elected its officers for the upcoming year, myself as the chair, Sean Emmerich as the vice chair, Stephen Reinhardt as the secretary. Committee also reviewed comments submitted on the rules proposed at the November Commission meeting to determine if any changes were warranted prior to adoption, and determined to recommend that the rules be adopted as proposed. Those rules are up for adoption under Agenda Item 15, and I'll be available to address any questions you have on that item at that time. The committee also discussed amending the rule requiring an inspector to provide a report to the client within 3 days, and asked staff to draft language to address those instances where the client has not yet paid the inspector for the inspection report for the committee to consider at its next meeting. Additionally, the committee asked staff to investigate the logistics of allowing an inspector to earn continuing education credit for attending any of the quarterly meetings of the full committee other than just the February meeting. Staff provided the committee an update regarding potential solution regarding the conflict that occurs with the prohibition contained whenever a broker requires payment for inclusion to preferred service provider lists. This item was brought up at the last broker responsibility work group to consider possible solutions. I attended that working group meeting to provide additional insight on that matter. The committee was told that the issue will be addressed in the near future. There was a lot of discussion on that, and to clarify what Mr. Jones had been talking about, pay to play is just a common term that we've been using. The concern that we have, at least from the inspector side, is we have rules from the inspector side that state that we can't be a part of exclusionary programs like that, to which if you pay to be part of that program, then other people are, in essence, told they cannot even walk in the door, talk to the agents, put materials out and whatnot. In no way are we trying to limit a broker's ability to market or advertise or anything of that such. We have rules as inspectors. We're not allowed to be a part of those programs, but there's no such rule on the agent or the brokerage side. So we're just looking for equal opportunity for that. And General Counsel actually proposed a rule which was identical to the rules that are imposed on inspectors to be imposed on the other side as well. And it was my understanding at that meeting that everybody was pretty amicable to that. They did not want to take action on it at that time. They wanted to do a little more research, have some more discussions and whatnot, which is perfectly fine. I just would hope that that issue does not die or go away anytime soon. I can tell you that there's a lot of preferred service providers that are taking issue with this, that would like to see something done, but I think there's a fear of retribution on that. I know that myself, I have received a multitude of emails, phone calls, and texts from residential service companies, mortgage lenders, title companies, whatnot, all expressing that they would like to see this put into place. They are trying very hard to play delicately because they don't want to rock the boat. So just something to consider. Finally, the committee recommended to move forward on the Inspector Committee Education Subcommittee's recommendation for streamlining the inspector pre-licensing education requirements to reduce redundancies and ensure the content aligns with the inspector licensing exam subject matter as directed by the Sunset Commission. The Education Subcommittee has also met twice since the last Sunset recommendation, but provides a simpler pathway to inspector licensure while focusing on quality education rather than the quantity of education. This item will be addressed under agenda item 23. I will be available to address any questions you have at that time as well. The Education Subcommittee will meet again on February 26th to discuss possible updates to the 4-hour inspector legal update course. The SOP Committee will meet on March 18th, and the full committee will meet again on the 15th of April. I can tell you on the Education Subcommittee, we have some of the strictest requirements for pre-licensure for inspectors in any state in the entire country. And it's always been previously looked at as we see shortcomings in the education of possibly some of our colleagues, so we're trying to bump the education up, never lower the line, trying to increase the line. So based on the Sunset Committee's recommendations and some recommendations from our own colleagues as well and on our committee, we want to make sure the quality of the education is there. We have a lot of inspectors. There are over 3,100 actively licensed professional inspectors. There are 3 different license levels, but on the professional side, there's about 3,100 actively licensed. And almost 50% of those have come from licenses within the last 2 years. There's a lot of turnover in our particular industry. So a lot of the feedback we've been getting from a lot of new inspectors that they get out, they get all this education, get all this stuff done, they go out and they're scared out of their mind because they aren't quite sure exactly what they should be doing on that first inspection. So we're trying to address that by adjusting a lot of the pre-licensure, and the Education Subcommittee has spent a lot of time on that. And to address your earlier question about the application tick down, so to speak, in the original applications, I've been doing this long enough to know that as the market shifts, which we are currently in the middle of a bit of a shift, that is almost one of the first things that starts to go down is the inspector license applications as opposed to agent and salesperson license applications. So we start to see that go down. There's a pretty good, you start getting a saturation point, and I think we're kind of crossing over to where we'll get a little bit different balance. But there's definitely a paradigm shift in our industry right now. I think there's a market correction possibly going on with the number of licensees, and I think that's a big reason why we're starting to see a downtick in that. I would expect that to probably continue in the upcoming quarters. Excuse me. The enforcement has seen an uptick in the amount of complaints that have come against inspectors. Many of these are initiated by the consumer, but in the end, most end up being administrative issues that enforcement division sees within the scope of their research of the actual complaint. A lot of people love to complain on inspectors. When they actually file the complaints, a lot of times the enforcement committee will go through, may not have a valid complaint, but there may be a form issue or something of that nature that comes across. So if you look at the disciplinary actions that have come through, you'll see a lot of those that are really administrative penalties in those respects as opposed to not functioning within the proper purview of what they're supposed to be doing on inspection. Standards of Practice Subcommittee is in the process of reviewing the current standards of practice. This process started last year, and we project this to go on through 2019 and possibly 2020. And that is all I have, and would be happy to answer any questions you might have.
Madam Chair, Chairman Lee, good presentation and congratulations on your chairmanship. Page 197, you can go back to that, and you sort of answered the question. We show a dip in inspectors applications.
Yep, they've actually pulled it up.
It stands out better when it's in red. And the reason I'm bringing it up is, and you mentioned that maybe there's a correction in the market. How will that impact the consumer or the home buyer?
I mean, initially you can say that there may be less choices, but realistically, I think based on what I'm seeing, not only from my own observations, but from the observations of different trade associations, which I always try to keep in good communication with, education providers and whatnot, there are a lot of new inspectors out there that are having a hard time getting going. I think there's a number of reasons that happen as a result of that. There's a lot of inspectors that are now starting to become part of larger national organizations, as opposed to starting off individually. I think that's been a much bigger shift in the last 2 to 3 years than I've seen in previous years that have been there. So,
how will that impact the real estate agent?
How will it impact the agent? My big thing is to make sure that agents are actually, when they refer any inspector that's there, that obviously there's a multitude of them, and that they verify that those agents, or excuse me, that those inspectors are actually licensed. There have been a number of instances we've actually had in previous disciplinary actions where there is one particular inspector who's had multiple violations due to unlicensed activity. The commission is obviously limited to what they can do in those scenarios, but education of the agent has always tried to be primary for us. That's really what our job is, educate our consumer and the agent. I don't see this as having a big negative impact on the agents. I think there are a substantial number of new inspectors that are out there that are hungry, that truly want to learn. They're joining trade associations, getting a lot of education when they don't have the initial inspections on the upfront to do that. So I think it'll actually be good, especially with the pre-licensure changes that we're talking about. I think that's going to have a very positive impact on the consumer because we'll have a better educated inspector that's out there.
Madam Chair, is it this meeting we're going to talk about inspectors and the recommendation that they minimize ride-along programs from 10 to 2 or something like that?
It's the next item. It's item number 15.
Okay, perfect. Thank you.
You have some there in 23, right?
I'm sorry?
You have things on 15 and 23.
Apparently so.
And isn't that right? I think. Okay, go ahead.
I just wanted to comment. I've been here, believe it or not, 6 years now. And ever since I've been here, the education standards for inspectors have clearly been evolving. And to put it mildly, it seemed like at times it's been a moving target just to figure out what the standards are. I just wanted just a little bit of brief commentary from you since this is the first time we've heard from you, at least I have anyway, on how you feel the sort of standards are and how you balance the need to have qualified, well-educated inspectors while also having the need to have a balance of enough inspectors to deal with what is a very robust real estate market in Texas. And furthermore, if in your opinion the existing standards are in any way serving as a barrier to entry, an unnecessary barrier to entry into this industry for people who might be interested in it.
I don't think that the current standards provide a barrier. I think if we had if we didn't see the kind of numbers that we've seen in the last 2 years, I would think that the requirements, the pre-licensure requirements would have been, there could have been an argument that has been excessive. We have had quite a bit of changes even in the last 6 years. I've been here 6 years as well. We've kind of taken the perspective of, we know that something's wrong. We're not sure how to make it the best as possible. So instead of sitting back and waiting, we're constantly trying to evolve it and make it better. And we'll try new things. If it doesn't work, great, we'll try something else. And a lot of times that has been increasing the education that's there. That's a big part of it, and I think that helps. But I think the current recommendation that's coming before to completely change the pre-licensure is a huge paradigm shift in how we've done this previously. And everybody has their own viewpoint, but I think everybody on the Inspector Advisory Committee has been very open and willing to give this a shot. I think the directive there, and a lot of this comes from the directive of the Sunset Commission to reduce a lot of redundancies and those types of things as well. So we're trying to address all those concerns while having this one big shift. So instead of playing little ticks at a time, let's just scrap it, start over, and let's make this work the way that it is. Thank you. All right. Thanks.
Thank you. Agenda item 15.
Good afternoon, Madam Chair and Commissioners. Carrie Lewis, General Counsel. Before I get into agenda item 15, I'd like you to turn to page 248 of your materials. After the last meeting, there was a request to somehow make the motions simpler or easier and have more options. So there's a new format in your motions, as you can see on this page, and staff, when they make a recommendation, will make their recommendation in the form of a motion that you can either move forward, reject, or accept with changes. So hopefully, you'll see this as we go through the material. Hopefully this answers some of the concerns that you have, and we'll make it a little easier, and only one of us will have to say all the mumbo jumbo stuff, and right now that will be me or Kristen. Okay, so let's go back to 15. This is the discussion and possible amendments to 22 TAC Chapter 535, Subchapter R. And all of these have been proposed. Some of them have been proposed, sent back, or tabled, and are now back before you for adoption. Actually, we had a reproposal of some of them for a technical correction. But all of these have been vetted by the Inspector Advisory Committee at 2 meetings. First in December, at their December 3rd meeting, where it was specifically sent back to discuss, in particular, the number of ride-along students. You'll recall that the Inspector Committee wanted the ride-along student per teacher ratio to be 2 instead of 10, and someone in the industry got up and spoke, or the provider got up and spoke and said, that's not going to be cost effective, let's make it, I believe he said 6, and I think you got a letter from him subsequently that said 5, a different number. I think everybody pretty much agrees that 10, it's not effective learning. So that was before them. The other issue that was before them that we have had comments on is the removal of the one option for ride-along, which was, I believe, a 16, which was less hands-on time and more actual video training that has never been taken advantage by any student. We haven't had a course available. No student's ever taken it. And so the committee also felt that it wasn't enough, and that video training for a hands-on portion is not a good substitute for actual in-person training. They voted on that in December. Then they developed this new plan. In February, they voted on these rules again to move them forward. And the main consideration why it was again on their February agenda, which was just last week, was because they've now have this new education plan, and is it necessary to move these forward with a new education plan coming forward? The committee felt that indeed it was, because of it's going to take some time to get a new education plan in place, having to go possibly through legislative changes, rule changes, and then time frame of changing to implement it, including staff time and then time for providers to do it. So these changes in these rules have been vetted and will serve the public well with a better educated inspector going forward, as far as the Inspector Committee believes, and that it's worthwhile having them in place even if it's only for the next year or so, depending on how long all this takes. There was one written comment. It was very similar to what you have received in the past from the same out-of-state provider, requesting that that he offer the video format in addition to not just having the 40 hours of ride-along field work. I think you subsequently got a letter regarding the number of ride-along students. So that's the background. Would you like me to make the recommended motion before you have comments, or do you want to hear from people?
Why don't you put the motion up, and then I'll ask for the speakers to speak.
Okay. So staff's recommended motion is that the commission authorize staff on behalf of the commission to submit for adoption amendments to 22 TAC Chapter 535, Subchapter R, as presented to the Texas Register, along with any technical or non-substantive changes required for adoption.
Okay, so we know what you are proposing now. We have two speakers, and I would, you may take your seat. Remind the speakers that you have 3 minutes. Please do your best not to repeat each other. And I would call Mr. Harbuck first.
Thank you, Madam Chair, and Commissioners of the Texas Real Estate Commission. I really appreciate the time and conscientious effort that you make in your role and duties as commissioners. First, just a quick preview. I don't want to go into a lot of detail. You have a lot of notes on that already, and I appreciate you reading it. It sounds like many of you have. But just a brief review, because this is our consciousness in this meeting, just as a reminder. Some of the previously submitted are that the proposed rule change on this is on the 6016 rule, by the way, which is 15B, should not be made. The difficulty increases by about 15 times. I mentioned that before. The inspector committee stated that they had no documentation suggesting live in-person on-site training is the only effective method to provide this type of training in their last meeting, and you can watch the video of that if you'd like. Skip past one of these here. For policy reasons, I asked the commission to avoid unnecessarily restraining entry into the profession under the sunset standards. Those are sunset standards that address that issue. There were some other additional reasons that I had left in some of those notes as well, too. I won't go into those. Some of the newer developments did not have the opportunity to speak in the inspector committee meeting. Not that I'm such a powerful speaker that I would have convinced them otherwise, but I do believe that it's an important part of our process regardless of the outcome, and also had concerns about the impartiality of the chair in that meeting as well. The rules will likely change here. We are in the process now of beginning to make a major shift here. If I could use an analogy, if we're safely moving passengers on a sinking boat to another boat in a timely fashion, should we move the orchestra chairs around on the sinking boat? The other things are the finalization date of the new curriculum is uncertain. We certainly would hope that we all hope, I'm sure, that we could meet the Sunset Commission deadline on this, which is January 1 of next year, for having final rules and so forth. But no one can guarantee that. And unfortunately, there's also added on to that, once the rules are finalized, of course, we all would want to try to have a course application in for a course before the rules are finalized, but until they become finalized, we aren't really in a position to start working on that because they can change. So once the rules are finalized, there's also a lag time in getting the courses approved. We spent, because of the limited number of staff that have been allotted to course approvals for home inspectors, as far as we can tell, it took us 6 months to have one course reviewed. I would easily suggest to you that we would need to tack that on. So that would mean that it would be well over a year from now before that could happen. My recommendation.
Wind it up.
Okay, sorry. My recommendation would be that you send this item 15 back to the inspector committee and ask them to allow public comments on it. Thank you for your time.
Thank you.
Appreciate it.
Mr. Harbuck. I'm Mr. Harbuck.
Mr. Harbuck.
Oh, I'm sorry.
I have a question for you.
Oh, yes.
You mentioned impartiality by the chair. What is your concern?
Well, while there's a lot of subjective evaluation of whether a chair is impartial or not, that is their role under Robert's Rules of Order, generally speaking. So addressing issues of substance about a motion, typically the standard is for the chair to recuse themselves and to allow someone else to take the chair position to address that particular motion. Certainly, if they're making the motion themselves, then they have to. But I think also it's a matter of the type of discussion that's a part of a motion to make comments that might lead some of the members of that committee to think that, oh, the chair's not for this, you know, may limit discussion. I think that's one of the reasons for that rule in Robert's Rules of Order, is that you don't want the chair saying, you know, I want everybody to know right up front, this is how I feel about this. Well, I mean, most members on a committee, I serve on some national code committees, and if the chairs there were to suggest things like that when they started in these committees, they would always get their way, but there would be a lot of frustrated people, you know, on that committee that would feel like they didn't really get a fair hearing for a proposal they might have suggested. You know?
Thank you, sir.
Thank you.
I'd like just remind the staff and whoever is present at commission meetings to please, I'm not sure what happened, but I believe it was Mr. Harbuck who had submitted a request to speak. And we need to make sure that that people who wish to speak, that they have the opportunity to be heard, that even though it might have been a slip by the chair, I appreciate you coming over today, sir, and making your thoughts be known, but we need to make sure that we don't do that. Thank you.
Chairman Moran, did you want to address that? You have a limited amount of time.
I would like to address that very quickly. First off, on the 10 to 2 rule, that has come up multiple times. We allowed 10 students per instructor. Once the 40-hour rule went into place, the ride-along rule went into place, we got a lot of concern that we would be hampering the ability for people to become an inspector. The rules that Mr. Harbuck is talking about, how it makes it 15 times harder and those types of things, if the rule had ever been used, and now we're taking it away, I can see where that would be the case. However, the numbers clearly state, even just in the last 2 years, since 40-hour rule and all these have been in place, that is not the issue. In regards to Mr. Harbuck's inability, as he states, to speak his mind or to present, unfortunately, that is not accurate. First off, in December, when this was first brought up and brought before the IAC, Mr. Harbuck expressed his concerns, completely understood his concerns. I was not the chair at that time. I expressed my concerns, just as we did in any other normal discussion. He submitted his concerns in writing as well. It was proposed, we brought it to the commission, and then we brought it back for some clarification, and then are now re-proposing it again. In the most recent meeting last week, there were 2 agenda items that really addressed this on our agenda. The first one, as there was some interesting time as far as electing chair and vice chair during that meeting, I fully admitted that when we went through that first item, I neglected to allow the public comment, and that was my fault. I publicly apologize for that, and I personally apologize to Mr. Harbuck for that, at which point at the meeting, he stated it wasn't a concern, wasn't a big deal, because he still, at the very next agenda item, got to get up and speak and give every point that he wanted to make on that. And he specifically stated that to me personally, that it wasn't a big deal because he still got to state the case that he wanted to make. We had a number of discussion on this. We've had a lot of concerns that video education doesn't even come close to comparing to physically putting your hands on an electrical panel and an HVAC and a water heater. There is no amount of video that will take that place of the interaction and physical touch that you would get. And so the entire committee, regardless of the assumption that one person is controlling the committee, I think if you watch that, you would understand that is absolutely not the case. But we have absolutely heard his arguments. He was always welcome to make it. There was one procedural error that I made, and I publicly apologize for that. That was my mistake. But he was allowed to speak about the same issue on the very next agenda item.
Okay, time up. You got a question for him?
Yeah, I have a question. Do we currently, with the continuing education standards for renewal, upkeep, whatever it is, do we allow for video to be part of that process?
I believe so. Yeah, there is some video continuing education that is allowed. And as an education provider myself, I can tell you, getting classes approved, I have never had one take 6 months to get approved. And I'm speaking on just the fact that I'm a licensed education provider as well.
Madam Chair.
Wait a minute. Did you want to?
I just want to clarify that the only video class that's being taken out of this is the one that would have been allowed to substitute for the 40 hours of hands-on training. All other courses, CE and qualifying, can be offered to our education department distance education, which can be, video online or classrooms. So it's just the part that would have substituted instead of 40 hours of hands-on.
Mr. Arriaga?
Two questions. Why the recommendation of 2 people versus 10? And how much does one pay to do a ride-along with you?
I am a registered ride-along instructor. I charge $100 for a ride-along on an inspection. My company, personally, that's what I do. The decision to go from 10 to 2 was from feedback not only from education providers, but current licensed inspectors and inspectors that have gone through that course. That you try to take 10 people up into an attic to look at an HVAC system, there's no way to do it. There's just no way. Now, this doesn't prevent an instructor from there being 3 instructors to one instructor having 2 people going up into the attic to look at the HVAC system, one instructor having 2 students at the electrical panel in the same house. They're certainly allowed the scalability to do that. But the ability for 10 people to interact and ask the questions that they may want to ask and get the education, the real world education that they want, we felt was extremely excessive.
$100 an hour, or $100 per visit?
I do $100 per inspection.
Inspection, okay.
Yes.
Thank you.
Mr. Leonard, did you have something?
It's kind of the same question, a little bit of a follow-on. Being respectful of Mr. Harbuck's comment about sending it back to the inspector committee, I believe you've had this issue
twice.
Mm-hmm. So I don't think sending it back to the inspector committee is going to change anything. I need to be convinced. We're looking at 2 numbers, 10 and 2. I can see where I'm going to put on my homeowner's hat. I don't want a mob in my house, and I don't think that mob is going to either be receiving the correct education that we want our inspectors to have. I can see where that's not workable. Now, I also understand that typically you don't have 10. The number you generally get is about 5 or 6.
I've had students, I've had recently licensed inspectors who have told me they've had up to 10 in their courses.
10 to me seems like too many. 2 doesn't seem like it makes sense for you. And if it doesn't make sense for you, are you going to continue to offer that service?
Oh, absolutely. For me, I won't do more. Actually, I don't like doing more than 1, to be perfectly honest with you. I certainly won't do more than 2.
Financially, I mean, if you're charging $100 and you've got 10 guys, that makes sense for you. If you're charging $100, you got 2 guys, that doesn't make as much sense. And that my fear is we're going to lose some of those professional instructors.
Anytime you have a rule change, that's always a possibility. And I will absolutely acknowledge that is certainly a possibility. We may lose ride-along instructors as a result.
If we have fewer people instructing and fewer people able to take the ride-along portion of what's required, does that provide a barrier to entry into the profession? My personal feeling, the number's somewhere in between those 2 numbers.
When we first implemented the 40-hour ride-along, that first year, there were 28 registered instructors for the ride-along course. And that was at the point everybody said there would be you're putting a huge barrier on becoming an inspector, and that was with 28. We're currently over 70 ride-along instructors right now. And I know most ride-along instructors that I know that do it on an inspection, they don't want more than 2 people that's there, because this is someone's home. And you're responsible as a key holder to get into that house. You are responsible for anything and everything that happens in that home with whomever you allow access to. That includes the buyer, but it also includes any inspectors that you may be training as well. And the thought process of having more than 2 people running around someone's home that they may currently be living in, I think there's a bit of a burden and a liability issue on the inspector as well that we could be pushing. Now, granted, a lot of the ride-alongs may not be done in homes that are a part of a sales transaction, but I still think one instructor to ask them to be responsible for more than 2 people in and of itself is a liability issue. I think from an education standpoint, like we talked about with the other item coming up on the agenda to change the paradigm shift in the pre-licensure, our goal is quality, not quantity. We want to make sure that the inspector, when they get their license, they are ready to walk out and go into someone's home and protect the consumer by giving a good quality inspection report and know what they're doing right when they get out of school. And we're trying to get as close to that as possible, and I think this gets us a good way there.
How many instructors are we going to lose if we change this to 2?
I'm sorry, I didn't.
If we change this to 2, and all of a sudden you've gone from, if you have 10 guys, and you're charging $100 a piece, and you're going to make $1,000. All of a sudden, you're not going to make $1,000. You're going to make $200. How many instructors are we going to lose if we change this from 10 to 2?
You're asking me to guesstimate? My guesstimate would be 10% or less, because I think the people that the 10 rule affects the most are the providers and not the actual inspectors that are doing an actual house.
And does 2 provide the right, is that the right, does that provide a good classroom experience? In other words, you mentioned your students asking questions. And if you only have 2, do they ask the right questions? Or if you have, let's say, 6, do you have, is that still a manageable number, but you have a better classroom experience?
I'm not sure that 6 is a manageable number, me personally. I don't believe 6 is a manageable number.
I don't know what the number is.
Yeah. Plus, I think that the more people you get, the less comfortable some people may be in asking a question for fear of somebody may not think they're intelligent enough or asking a stupid question.
Because I don't know, I'm inclined to listen to the inspector committee pretty seriously. Somehow it seems like we're overreacting.
We are reacting based on feedback we're getting from people that have actually gone through the process and been a part of it and gone through these courses where they have 40-hour ride-alongs, where there's an abundance of people there that feel that that was some advantage to do it, but it was just too chaotic to have an excessive amount of people that's there. And in many of those situations, you're right, those are like the 5 or the 6. The 9 or the 10 are the real extreme cases, and there just aren't that many of them. But our goal is to get back and make sure that they get the quality of the education that they really should have, so that when they go out there, because we have no sponsorship like an appraiser. You don't have to be a sponsor for 2 years. You go out and get the education. There's a fast track program, and we're statutorily required to have that fast track program so that there's no sponsorship requirement. So we have to do everything what we feel in our power to protect the consumer and get that inspector who's on the fast track the best education possible before they go out and are faced with the consumer.
Now, if we elect to change it to a different number, whatever that number is, that doesn't preclude you from limiting your personal class size to 2 or whatever.
Certainly does not. No, it doesn't.
You can still say, you know, anybody else can do whatever the number is. I only do 2.
Correct. I personally would not do 2. This started with the education subcommittee, and they had multiple deliberations on this, then came before the IAC, the full IAC, and it has come before twice. And it has always been a unanimous vote, both from the subcommittee and from the IAC, to go from 10 to 2.
Thank you, Mr. Chairman. Did you have another question, Mr. Arriaga?
Madam Chair, I've had the pleasure and pain of sitting through the committee meetings and subcommittee meetings. They know what they're doing. I recommend that we listen to them and recommend 2. We can always change it.
Did you have something, Commissioner Wilkinson?
I just have a quick question of general counsel, and that is this. It's a naive question, but I don't want to assume that we all know. You mentioned something that as a homeowner, I guarantee you I'd be very upset if I did not know that there were 10 inspectors coming through my home, or even 3 for that matter. Do you all have to get written permission from the homeowner to bring them into the house if there's more than 1 inspector along?
I don't know of any rule that requires that. As part of our MLS rules, you know, super key access, we are responsible for anybody that we let into the property. For instance, a buyer, the buyer's contractors, people that come do estimates. If the house is occupied, my personal policy is I don't let anybody in the house unless their agent is there to physically supervise what they're doing. Many inspectors have taken that on as well. Some buyers want to be there through the whole process, and if the inspector's supervising them, great. But otherwise, it's part of the MLS rules and what you sign up, the agreement that you make as part of a key card holder, that you're responsible for anybody and everybody and any damage that happens in that property while you're in it.
And I will say, Commissioner Wilkinson, that usually the ones that have classes of 10 are proprietary schools, and they have test houses.
Right.
Okay. Usually if you have someone who's just doing it on an actual inspection, they're just taking 1 or 2.
Let me ask you this question. Could you increase the number of homes by decreasing the number of people that you're training? We're talking about 10 and decreasing the number that you're comfortable with. Could you increase the number of homes you're inspecting?
Me personally, no. Because like I said, I don't take more than 2. and I'm going through the entire process of what I'm doing, and those people, I want them to follow me around, and I am talking through the process and letting them ask questions through the process, but I'm doing an active inspection where they are watching me not only test every outlet, tub, toilet, and faucet, but actually type up the report and watching over my shoulder while I type up the report and what I'm putting in and what I'm not. So for me personally, no, that would not change the number of how many inspections I'm able to provide.
Thank you. Did you have something you wanted to correct or something, Mr. Harbuck, real quick? Real quickly, because I still have a speaker.
The happy medium here may be, if you wouldn't mind considering it, to remember I'm talking about the 60-16 rule, not the going down to 2. Because I too believe that 10 is too many, okay? But the 15 times is when you combine both of those. I'd encourage you to consider 15B is the 60-16 rule elimination. If you allow that to stay, that reduces the number of hours that they have to go out with, whether it's 2, 5, or 10, so that it's only 16, which makes that less inconvenient, so to speak. Yeah, thank you.
Okay. Mr. Carter, are you still here? You have 3 minutes, but I'm not counting till you start talking.
Right. Good afternoon, Madam Chair and Commissioners. My name is Roy Carter, and I am the Director of Inspector Education for Champion School of Real Estate. You do have an appendix item that was in your packet, and I am here to answer any additional questions that you have regarding that item. I am of the opinion that, one, I would not like this rule to be adopted as it is currently, going back from the 10 to 2. I think that is a little bit too excessive. I think in the public protection side of the aisle, I think it will limit the number of inspectors that get in. I don't think that list that is currently out there, like I stated before at your previous commission meeting, has been properly vetted to know how many of those inspectors that are actually on that list will in fact perform inspections. We have done our own research off of that list. That number is down to about 30 to 35. 35 to 45 people on that list. And then, of course, we also, in that packet that you have before you, giving you some ideas of what the various inspectors also charge. Also, the various number of people that are on that list got on that list in order to actively train an inspector to come and work for them. They're not actively doing ride-alongs for the public at hand for any inspector that wants to, or any applicants that wants to go down that road. So therefore, that number is even increasingly low because they have no intentions on doing it any further than what they have already done it to meet their employment demands for inspectors. So I think this would be a burdensome on the entry as well as for the public protection, because this is going to begin to start limit the number of inspectors that we get out there. As you saw, or that came up, we're at 43%, right? And part of that is that barrier to entry, and I think this would be an increase to that barrier of entry. I also think that if we're going down the path of making this whole change, I don't see the point in doing this right now, which would also cause that increase in cost. Right now, if we're going to be making a change, it's going to cause us to do another change in a year, or less than a year, just depending on how long the committee takes in order to make the change based off the Sunset Commission's recommendation. So I think we're about to go do something that is going to increase the cost to get in, to turn around, to do something else that's also going to be a barrier. I don't understand why we need to do that. So those are my thoughts, and I'm open for questions.
Do you know what the increase in cost will be?
I think it'll probably fall between anywhere from $600 to $1,000. So, yeah. So,
yes.
If not more.
Mr. Carter, have you noticed a decrease of inspectors wanting to get a license?
Yes.
You have?
Yeah. Yes.
Do you know why?
I think primarily, when we went to the 394, we went to the proctoring. Proctoring was not that big of an issue. I think when we got to the point of people becoming frustrated that came into doing the coursework, when we went into the 3-day waiting rule that I think it was an unintended consequences on inspectors, where if you had an 8-hour course, because all of our courses are individual courses. It's not one big course. So we have 31 separate topics that they have to address. Each one of those has, like I say, topic quizzes. Each of those have exams. And so if somebody were to fail a 4-hour exam, they had to wait 3 days before they could take that exam. Students became very frustrated with that, and so a lot of them said, you know, I can't do this because I can't take this amount of time in order to get through this process, in order to start trying to get to my new career, to start taking care of my family. So they opted out, so therefore you have the limitations on the applications. And I brought this up back in November, and I keep bringing it up. I brought it up when it first came up, and then we're still back at this process.
From the day I decide to get a inspection certification license, how long does it take? How much will it cost me?
Well, currently, as far as our fees are concerned, it's $2,699 for the whole 394 hours for them to get their to go for a professional inspector.
Does that include the ride-along?
It does include the ride-along portion of it.
So it's not going to change?
No.
Thank you.
It will change if they go to 2. Definitely.
And time from, I guess, depends on how often you're going to go to class.
Well, that and some of it is at home, and then it'll be a matter of their own work schedule as to when they can actually get into the ride-alongs. But we offer ride-alongs every month, so.
Average time to get a license or a?
Typically, it's taken most of our students about 2.5 to 3 months, so.
It's a shortage of inspectors right now, isn't it?
There is a shortage of inspectors and has been for quite some time, so.
Okay.
Mr. Carter,
Yes.
within the last year, what changes can you tell us so that you can please put us up to speed on the changes that you have seen in requirements, education-wise and cost-wise, from where you were to where you are now, and why you're saying that it is a barrier of entry?
Well, I think the biggest thing that changed, one, when we went to the 394 hours, which wasn't that big a deal because we came back from 450 hours because that's what it used to be. I think we went to the 40-hour where before we were 120 hours of actual experience, lab, and field time. I don't think the barrier came in for inspectors is when we got to the proctored exams, and then we got to the 3-day waiting rule when it came to the different exams that they might have failed out of that 31. So you take 31 and somebody blows a couple of them, then you're out 3 days and then another 3 days. And so you take that time from that 2.5 to 3 months, what it used to be. Now I'm 4, 5, or 6 months. Well, I'm trying to get to a point to where I'm trying to get out here so I can do a different career and take care of my family. So now I got to go a different path because I only had so much money set aside to start this to begin with. So.
Thank you, Mr. Carter. Rebecca Hollett. Tell us who you are.
Thank you very much. Rebecca Ray, real estate broker, longtime educator, and had the pleasure of being the executive director to receive in what at the time was the largest inspection school in the state of Texas, very reputable, the American Inspectors Institute, that was founded and ran by Russell Burgess and his family. So my knowledge comes from him, and I think he's stirring me to come speak, so I'll go quickly. I think I have definitely heard we do have a problem with the ride-along being required to be live. It's not offered everywhere. Even if we've got up to 70 of them, look at where they are. That's a big problem. So being able to offer equally across the state, I work that North Texas border. That's a weak spot. I'm sure there are other weak spots. I don't know. But I think if we're able to open that window where there is either video or another option for folks that aren't in the large cities, that would be a big benefit to the consumers. Thank you. Yes, ma'am.
Do you happen to have an idea of the number of people who are outside the area, close to those main large cities where they can have access right along? Like, how many people is this affecting?
You know what, and it's been years that, just due to my past experience and so forth, that people have reached out to me and say, what do I do? I've got to go to one of these big cities, pay to travel, miss work, pay for housing, and the fees. So to your point, it's $100 per inspection, but how many inspections is it going to take me to get my full experience? And Mr. Burgess was also a genius. And we had the test houses, we had panels that were set up where you're able to put your hands on all the components. And honestly, I found that to be a much better program because it was consistent. Every home is different, and we found challenge in that. So it became very well offered and very consistent, and got to the point where we were even able to video a class, invite the students to swing by on their time and visit one of the test houses so they could feel the items, but they saw full interaction of everything on a consistent basis statewide.
Thank you.
Mm-hmm.
I will remind the commission that at the time this went into the law, then Vice Chairman Jones and I went to visit the actual congressman who wrote the bill, because there was debate at that time about whether he really meant real live, go put your hands on it, or he was just kidding and wanted video. And he was very, very, very clear that what his intent was in the bill, hands-on, show me what's wrong. I want to touch it, feel it, see it. I want them to not damage consumers by not knowing what they're doing on an actual hands-on inspection. And he was absolutely clear. I still have the binder with all that information on it. I'm happy to bring it and hand it off to someone who can carry this message forward when I'm gone. Mr. Westcott.
Makes a lot of sense, and that's why I think the inspectors want to keep it to 2 if they could.
Okay. Mr. Westcott.
Yeah, I have a motion, and I'm very sensitive to everything Mr. Lee said, or Mr. Warren said, and all the work that the inspectors have done. I'm also very, very much in agreement with Commissioner Leonard that this is a very serious issue, and having enough inspectors and an adequate supply of inspectors and able to keep up with the dynamic, evolving, constantly growing Leviathan that is the Texas real estate industry and market is absolutely essential. We need to make it easy for people to become inspectors. However, they need to be great inspectors when they do become inspectors. So we have to have the educational capacity for that. And so that's why I'm making the following motion. I move the commission approve staff's recommendation with the following change, and that is that section 535.2131C is changed from no more than 2 to no more than 4.
I have a motion. Do I have a second? Did you second that? Discussion?
Madam Chair, just one item I want to point out. Although what was handed out to y'all was the proposed change to Rule 208, although it's mentioned in your materials and the reason for its being there is mentioned, it's just a rule site. You didn't have the actual copy. Just want to make sure you had that. That's included in these rules.
Okay.
Thank you.
Madam Chair?
Yes, sir.
I will be voting against it, not because I don't like the ideas. I want to stick with the committee recommendation of no more than 2.
Okay.
Okay.
Cool. Thank you. Any other comments?
Madam Chair.
Yes.
As a matter of fact, I move to amend that motion to strike out 4 and put 2.
Okay. Is there a second?
I have a comment.
I understand, but I've got to have a second and I have no second. So yes, do you have a comment?
Yes, Madam Chair. That we just provide a benchmark, one high and one low, and let the people and the instructors and the public decide what is best for them, because it's a matter of need and money, and why don't we just do that? Let them. So I move that.
Go ahead.
That this commission not approve staff's recommendation, but that we set a benchmark between 2 and 10 and let the people decide what is best for them.
Well, the motion was 4. She's asking to amend the motion.
Second.
To a range between 2 and 10.
Madam Chair, may I get clarity?
Yes.
Commissioner Stevens, when you say not to approve staff's recommendation, do you mean just on that one particular item because there are other changes in these rules that are proposed? Are you talking about just not accept the recommendation on that one particular item?
That particular one,
Right.
Yes.
Then you probably wanted to amend your motion to be that you approve staff's recommendation except for the following change. And
She's
then
actually amending his motion.
she's meant, okay. It's just she
accept it
stated
all.
to not
Right, I
accept that.
understand.
Okay,
And-
just wanted clarity, then we'll go with that if
and
that's
I have
what you meant.
May I ask a question of the motion maker? Would that preclude someone, I guess, the way you've stated it, from having one person?
no, you're right. I think that we should go from 1 to 10. You're absolutely right. Thank you.
And I had a second, right? To
Correct.
amend it.
Although, all due respect, we're not changing anything.
That's right.
Yeah, literally, that's what the existing deal, yeah.
Okay, but we still, we have an amendment. Let's vote on the amendment, which is a range from 1 to 10. All in favor of basically leaving it as it is, say aye. 1 to 10. Nobody's talking, not even you?
Yeah.
Are you
Aye.
not going to vote for yourself?
Aye.
Oh, well, I got one aye.
Aye.
I got 2 ayes. I got 3 ayes. And opposed, no?
No.
No. Did you, okay. I don't think we have that. So you want to go back to your original?
Yeah, I mean, I just-
We did not amend the motion, so now we have the original motion not amended to be no more than 4. On the table.
Yes.
He didn't get a second. So, any discussion on the original motion to go no more than 4 instead of 2, whatever, substituting 2 for 4 in 535, 213.
Just briefly to address your point, why not just, kind of open it up and let people decide entirely, is that, our number one goal here is consumer protection, and we are balancing 2 very important things, one of which Bob, and I have kind of harped on, which is we need to have enough instructors, and we need to have, good instructors, and also the concerns that Mr. Warren raised, that, he's wouldn't even have, more than 1 or 2, because that's how he feels, and he wants to be responsible for those people and make them the best they can be. So I think 4 is a number that is reasonable, in which you can keep your eyes on 4 people. And 10 was clearly, an unwieldy number. So, that's how kind of I arrived at balancing those 2 interests. So with that all being said, I'd like to move the question.
Okay, we have a motion. We're going to vote to accept all of this to be proposed. You understand? This is just being proposed.
No, this is
Oh, this is adoption?
Yes, you're wrong.
Okay, I lied.
Make the
Then-
change
then we're
because
going to
4
adopt.
is less restrictive than 2, so it's a non-substantive. It's not hurt, it's less restrictive, so you can go ahead and adopt it with that change.
Okay, good. So we're going to adopt this. All in favor of everything except going from 2 to 4, say aye.
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 Aye. And no, nay if you're opposed.
At the risk of sounding negative, but I need to carry the flag high for the inspectors. They've been working their bottoms off, and all due respect to them, I will vote no.
Okay. The ayes have it. So we're going with 4. Okay, we're on agenda item 16, and I'll just tell you that those of you that have been here, you've actually only been here in an actual meeting 4.5 hours, so don't be freaking out. We're almost to 19, where you'll get credit.
Madam Chair and Commissioners, before you in Agenda Item 16 is discussion and possible action to propose amendments to 22 TAC 533.8, motion for rehearing. The proposed amendments to this rule clarify the methods for filing a motion for rehearing with the Commission by adding the email address and the facsimile number to which the motion may be sent. The proposed amendments are recommended by the Enforcement Committee, and staff's recommendation is that the Commission authorize staff on behalf of the Commission to submit the proposed amendments to 22 TAC 533.8, motion for rehearing, along with any technical or non-substantive changes required for proposal, to the Texas Register for publication and public comment.
We have no speakers on this. Ms. Miller?
I move that we accept staff's recommendation.
Oh,
Second.
whoa. Any discussion? Whoa. All in favor say aye.
Aye.
And opposed, no. Motion carries. Agenda item 17.
Madam Chair and Commissioners, this agenda item is regarding proposal of amendments to 22 TAC 535.141, initiation of investigation. The proposed amendments to this section would change the caption to clarify that this section also includes order requirements. The proposed amendments also add language to clarify how agency prioritizes complaint investigations as required in Occupations Code 1101.204. The amendments as proposed would remove existing language from subsection B, since that language is proposed for inclusion in new section 535.142, and correct a typographical error by inserting a missing period to the end of subsection F. The proposed amendments are recommended by the Enforcement Committee to implement recommendations of the Sunset Commission. Staff recommends that the Commission authorize staff on behalf of the Commission to submit the proposed amendments to 22 TAC Section 535.141, initiation of investigation, along with any technical or non-substantive changes required for proposal to the Texas Register for publication and public comment.
Madam Chair.
Yes, ma'am.
This is in part of the Sunset Commission recommended that we prioritize any complaint that comes in from the public. But the initiation of investigation, that was brought up by this agency when we first started doing the advertising rule. And back then, it was proposed that we have enough on our plate. I think trying to enforce this at this time, I mean, we would have to go and be actively investigating, and we have always been driven by consumer complaints which are in writing. So Madam Chair, if I may, I'd like to make a motion.
Okay.
I move that that this commission approves the staff recommendation related to in accordance to the Sunset Commission recommendations to prioritize the complaints which come from the public, but to discard the request to initiate investigation.
If I might, Madam Chair and Commissioners, initiation of investigation is simply the caption, the title of this rule. So there's no change to the process by which we would initiate investigations. We are still a complaint-driven agency under this rule. We would not be able to initiate an investigation without receiving a signed written complaint.
But that's not what the rule says. And if you read that, I mean, that grants permission to this agency to initiate, this is on page 267, initiation of investigation. I mean, all that it would take would be for this agency to actually investigate that. So if we're going to do that, we need to write it properly, and that's not what it says.
I have a question.
Wait just a minute.
I believe you're referencing the first part of the rule, which is subsection A and B, and there is no change being made to those subsections.
Can I
To 535.141, which
Yes,
is the
ma'am.
whole.
So essentially what we are doing is we are adding new language to subsection C, and we are removing the language that is currently in subsection C, because that will become part of the new rule
could we
under the next agenda item.
just a thought? I think we could probably fix this with one word, and investigates received complaints as follows. With that,
I have a question, Madam Chair.
Okay.
We're doing this to save time, because all we're doing is striking out what's in red and adding the paragraph at the bottom, which is no change in an F. Is that correct?
No, as you may recall from the Enforcement Committee meeting, this change is being proposed in connection with the new rule that you will consider in the next agenda item 18, which is the process that the Sunset Commission wanted us to implement, a process for investigating complaints.
So, do you want to make a motion?
Yes, I do, and I just want to, because I understand her concern and how that was confusing. Just the language with C, doesn't make it clear that these are investigates complaints that the commission has received, as opposed to investigating, I don't know, just anything. So just to clarify that, I'd like to go ahead and make the following motion. Move that the commission approve staff's recommendation with the following change. Section 535-141. C is changed to, and then I'm going to the second clause here, the commission prioritizes and investigates received complaints as follows.
Received. Complaints received by the commission.
Complaints received, yes.
That's fabulous. Thank you.
I didn't follow the change, Counselor. Where's it?
So under 535-141
Right.
C.
Using criteria?
Yeah, using criteria. The second clause, the commission prioritizes and investigates received complaints as follows, or
Complaints received by the commission.
Complaints received by the commission. Yeah, that's fine. As follows.
And that's consistent with the statutory requirement that says we must have a complaint.
Everybody understand that? Do I have a second?
I second it.
I have a second. Is there any further discussion?
Yes, this came from the Enforcement Committee that Commissioner Bob and I were in, and it had to do with Sunset. But does that meet what we need to do?
Yes.
Okay. Call for the vote.
All in favor, say aye.
Aye.
And opposed, no. Agenda item 18, motion carries.
Madam Chair and Commissioners, agenda item 18 is the proposal of new Section 535.142, Consumer Complaint Processing. This proposed new rule specifies the steps to be followed by Commission staff when processing and investigating consumer complaints received by the Commission. This new section also includes the language from Section 535.161 in this chapter, which is being proposed for repeal under agenda item 19. The proposed amendments are recommended by the Enforcement Committee to implement the Sunset Commission recommendations, and staff recommends the Commission authorize staff on behalf of the Commission to submit new 22 TAC Section 535.142 Consumer Complaint Processing, along with any technical or non-substantive changes required for proposal to the Texas Register for publication and public comment.
Madam Chair?
Yes.
I move that this commission approve staff's recommendation.
Second.
And I have a second. Any
Who
discussion?
wrote this up?
Lawyers.
Carrie, did you do this?
Very well.
This was proposed by the through the Enforcement Committee by the Standards and Enforcement.
Kudos. You see sausage being made every day in legislature. This is one brand new rule that we came up with, and that's because Sunset is making us do this. But we reads pretty.
All in favor, say aye.
Aye.
Any opposed, no. Motion carries. Agenda item 19.
Standing between you and approval of CLE, or CE, sorry, continuing education. This agenda item involves the proposed repeal of 22 TAC Section 535.161, failing to provide information. The repeal is necessary because the language for this rule is being proposed for inclusion in a new rule, 22 TAC 535.142, Consumer Complaint Processing, and this section is not referenced in any other section in Chapter 535. The proposed repeal is recommended by the Enforcement Committee, and staff recommends the Commission authorize staff on behalf of the Commission to submit the proposed repeal of 22 TAC Section 535.161, failing to provide information, along with any technical or non-substantive changes required for proposal to the Texas Register for publication and public comment.
Moved.
Second.
That the staff approve, that the commission approve the staff's recommendations.
Second.
Any discussion? All in favor, say aye. Aye. And opposed, no. Motion passes. Do they have to sign out to get CE credit? So sign out. Thank you for coming. Thank you for your patience. I appreciate you. It was really only 4 hours and 40 minutes that you had to be here. I'm going to let them clear out for a minute. I'm going to move agenda item 24 to next and get the forms out of the way. Ms. Jackson, you're going to be next.
24.
24. Pay attention.
I didn't. I just wanted it to be over.
I don't either.
It just felt like. Two just seemed like two.
Are we taking a break?
We're not taking a break. Thank you. Yes, come on up. Looks like we're taking a break, but we're not.
As you're leaving the room, if you could please be quiet, we are still in session. Thank you.
Hey, boys and girls, we're still in session, so please be quiet. Don't leave the room if you're on the commission all at once. Did I just lose a quorum?
Oh.
Maybe 5-minute break?
2 minutes or something.
I guess we'll take a 3-minute potty break.
First time we've ever had a 2-day meeting, for sure.
Yeah.
If we have a 2-day meeting.
We're going to have a 2-day meeting.
Thanks for making my day.
Okay, call the meeting back to order. I don't think so, but thank you very much. We've moved agenda item 24 to next, and Ms. Jackson is going to present some forms for real estate schools.
Yes. Madam Chair, Gwen Jackson, Director of Education and Licensing Services. We have 8 forms to discuss and have possible action to approve them. And they're forms that are either new or changes.
Oh, wow.
And I will summarize them as I go through here. The first form is QECA-1. It's the qualifying real estate course application that's used for pre-licensing elective and advanced qualifying courses. And the revisions to this form include... Can you hear me now?
No.
And revisions to this form include a checkbox to specify whether pre-licensing elective or advanced course submission, an area for the provider to specify the course subject, and language that encourages providers to submit materials via flash drive, Dropbox, OneDrive, or by other electronic means that will minimize the receipt of paper materials. The next form is the QECR-0, which is a renewal of qualifying real estate course approval form. And this form is to be used to request renewal of a qualifying real estate course approval. It aligns with recently adopted rules that allow for a true course renewal. The CECA-4 Real Estate CE Course Application Form is to be used for elective CE courses. This form was revised to allow providers to select whether they're wanting to offer a general electric course or a contract course to correspond to rule changes effective September 1 of this year. The CE-CR-0 or O form, which is a renewal of real estate CE course approval, is to be used to request renewal of a real estate CE course. It aligns with recently adopted rules that allow for true course renewal. Also allows providers to select whether the course is going to be a general elective or a contract course to correspond with rule changes effective in September. Then there's the CECASP-O form, 0 rather. It's the real estate CE course application for secondary providers. It's to be used by a secondary provider when requesting approval to offer a real estate continuing education course that's currently approved for another provider. and it also aligns with recently adopted rules that change terminology to more accurately reflect industry terms. There's the ICE RCR-0 form entitled ICE Credit Request for a Course Taken to Maintain a Related Occupational License. This form is to be used by inspectors when they're requesting inspector continuing education credit for a course taken to satisfy continuing ed requirements for a related occupational license. This one aligns with recently adopted rule changes to 535.218 to allow inspectors who hold a similar active occupational license to request inspector CE credit for those courses. The next form is the ICE CR-0 form entitled Renewal of Inspector CE Course Application. This one is to be used to request renewal of an Inspector Continuing Education course approval. It also aligns with recently adopted rules that allow for a true course renewal. Then the last form is ICE CASP-0, which is the ICE course application for secondary providers. It's to be used by a secondary provider when requesting approval to offer an ICE course that's currently approved for another provider. Again, this one also aligns with recently adopted rules that change terminology to more accurately reflect industry terms. Staff recommends approval of new or changes to TREC forms as presented.
Commissioner Miller?
I move that the commission approve staff's recommendation to approve new or changes to the TREC forms as presented.
Second.
I have a motion and a second. Is there any discussion? All in favor say aye.
Aye.
Motion, all and opposed no. Motion carries. Agenda item 20.
Madam Chair,
Yes?
Ms. Pifo had to go upstairs to release a batch, so she is not here, and she's
Okay.
giving that item. So you might want to move to one of the other items.
Sure. Which one were you going to do?
I would say probably 25. I think 22 and 23 might be more appropriate for in the morning when everyone's fresh, because there are going to be some long discussions.
Okay. Are we going to do 23 today?
That's your choice.
Well, I have several people who wish to speak, and I thought maybe we should do that one.
23. Do 23 first.
Who would be presenting 23? Well, what is 25?
I guess, yeah.
Legislative recommendation. What did you say?
Oh, okay.
Do 25, and then we'll go back to 23.
I'm a little worried about the comment about being fresh in the morning, because I may bore you into sleep. So I hope that doesn't happen. Tony Slagle, Deputy Executive Director. My shot at levity also fell flat. I apologize. This is I'm presenting on item 25. This is kind of a two-part thing. I provided you earlier with a copy of a list of legislation we're currently tracking. There are some typos on that, and I apologize. So I've got a fresh version of the report if you want it. Otherwise, I can email it to you after the meeting if you don't want more paper. But I'd like to start initially by talking about the item that's behind your tab on item 25, which is the 2019 TREC TALCB potential legislative initiatives. As some of you are aware, we were contacted by Senate Business and Commerce early in January, and they asked us if we had a list of anything outside of the sunset recommendations that we might, that if any of their members would like to move forward on, if we could provide them with a list of those items. And we met, and the executive director and myself met with the staff over there with a list of items. Understanding that there is a certain level of bandwidth that we all have in terms of dealing with legislation this session because of our sunset bill, we understand that it's unlikely that most of these would be something that would be pursued outside of a couple of board-related items, which would need to be pursued in order to help facilitate the sunset recommendations. I don't know if there's anything necessarily on the commission side outside of if you want us to pursue that would necessitate being done this session. So I didn't want to want the assumption that we were going to be, that this was a list that we were pushing or wanted someone to push or we're looking forward for you guys to weigh in on. Outside of that, there is an issue that we'll talk about under the sunset recommendations. There's some suggested legislation for to allow the inspector issue that we're going to be talking about under that to move forward, but that's not part of this list. So I'm happy to go through the list if you want me to. I know we're all pressed on time. I didn't know if you had any questions about it, if you've looked at it.
Is that this list?
It's the one that says 2019. It's the one that was behind the agenda item. No, this list I'm happy to go through because these are bills that we're tracking.
I don't want to go through that. I had a couple of comments on the wish list, and I don't know if others do, and this is just generally stuff we've talked about. I was looking at page 360, an item 9 that has to do with drones, and I was really appalled that we would put on here that we thought maybe we should be able to do a drone image without the owner's permission. And I wanted somebody to have a discussion about that, maybe.
Oh, I had the same thought.
Okay.
Could I ask a question? Does anybody here other than me own a drone?
Yeah.
Do you?
Yeah.
Okay.
Do we know what?
Do you own a drone? Okay, so everybody.
My grandson.
Anyway, so I'm somewhat familiar with the general laws regarding drones, and you basically all of the regular provisions that apply to free speech do as well apply to drones and photography and drone photography. So just as a starting point, I think that's a good place to start.
Okay. General Counsel, did you have some comments? One of you go. General Counsel is.
Yes. Yes, Madam Chair and Commissioners. This particular item was simply to, added for consistency's sake. The statute currently allows a real estate broker who is licensed to capture images using a drone in connection with the marketing, sale, or financing of real property. So presumably that means if you're the listing broker for the sale of that property, then you can use a drone to capture images to utilize in that marketing and sale transaction. The consistency or the reason we had included it on your list is to add language to allow other licensed persons like a real estate sales agent, inspector, and appraiser to capture images for those same purposes. And the statute already authorizes the capture of drone images if you have the owner's consent. There may, however, be a license holder, for example, an inspector or an appraiser who would not be working for the owner. That, in other words, that would not be the client. The appraiser's client is the lender, typically, in that transaction. The inspector's client could be the buyer or the owner-seller in the transaction. So this would be simply limited, again, to collecting those images to further the real estate transaction.
Okay. I appreciate that explanation. My next question had to do with allowing an unlicensed person to identify, that means call into neighborhoods and say, this is Ava's interpretation of what this says, you want to sell your house, and you're going to allow unlicensed people now to do that. I have a problem with that, if that's what that means. Does that what that means?
Yes, it means to ask the question, to simply ask the question, are you interested in buying or selling real property? And if the answer is yes, then to turn that lead over to a licensed person. So that currently happens. It currently happens already on websites. Okay, many agents buy leads from unlicensed people all the time. Well, all I'm saying, and all this means is that if, in fact, I mean, we obviously are very concerned that that all of the qualifying questions, all of the leading questions, all of those kinds of things that are that require or that could mislead consumers, that harm we're all aware of. But the mere asking the question, if you're interested in buying or selling a home, press 1, right? And then you're connected to a licensed person. You know, those robocalls are already happening. There are hundreds of websites that are asking that question. So either we ignore all of those, wait for somebody to complain about it, or we simply acknowledge that the mere asking of the question to produce a name and phone number or to connect a person to a qualified licensed person does not require a license. That's all.
Mr. Scott?
Is it our intent with this, unlicensed assistant rule to allow for sort of direct solicitation, as in, making calls, going door to door, or is it simply, technological and, a website or a robocall?
It's just to raise the topic. That's all it is. I'm sure the technology, the public policy interest that we have, of course, is to make sure that people aren't taken advantage of or misled. That's us.
I guess this is a matter for the legislature.
It is.
Yeah, but I would just think that, we should be wary of allowing unlicensed people to directly solicit, door to door or over the phone. That sounds an awful lot like real estate activity.
Thank you.
I did want to make a correction on something I stated. There are actually things on here that would be tied to the commission and moving some sunset things forward. One is just to make sure that if the residency requirement goes away, that there's something in the statute allowing the commission to speak to geographic competency. That's number 5. And then number 7 and number 4 were already brought forward to the commission in November by the inspector committee as items that you guys voted on to move forward to the legislature. So I apologize for saying that those items are things that we would likely address when they come up.
Anybody broadly, you have something else? Yeah, Mr. Arriaga?
What is in the agenda is good, but what's better was passed out this morning.
The
that
bills? The bills?
Yes.
Yeah, that's next.
Oh, okay, I'm sorry.
Anybody else have anything on what came in the materials? General? Does anybody have any just general comment? This is, we're kind of at the place now where we're doing a little bit of a deep dive into things and having a little more liberal discussion than just trying to get our business done. So I was just seeing if anybody had any on these pages that came with the materials that we've been talking about. Any other comments? And then we'll get into the bills.
Madam Chair?
Yes.
I am clarifying this, are these initiatives from TREC, or are we just following up on them because somebody else is initiating? That's my question.
Well, Tony mentioned the ones that we've already taken action on, and some of those were pursuant to the Sunset Commission's recommendations, and then some of this, they're just putting out there.
We had been asked by the Business and Commerce Committee to come up with a list of legislation, so we looked at our strategic plan, which all of you voted on in terms of legislative initiatives moving forward, as well as some other issues, and we just provided this list. As I mentioned when I started the presentation, that knowing that our bandwidth is short in terms of the sunset legislation, there's going to be only certain things that we can focus on, that we wanted to focus on the things that would help move the sunset recommendations forward. So while this list is all that we provided, it's unlikely, unless they came up from a legislator and they wanted us to weigh in on it, that we as staff would be, looking to weigh in or pursue on any of this.
So these are all ours. These are all from the agency, we're not really following. We're just.
Yeah, these are all recommendations that came up at one point or one form or fashion throughout the last couple of meetings from both TREC and the board and the appraiser board.
Okay.
Yes, ma'am.
Do you have something, Jan?
Yeah, I was surprised that commercial brokers didn't come out against the residency requirement. Was there any conversation, or have these items all been vetted within the
It did.
broker realm?
I was there and spoke about that specifically, and Bill left, but opens up Pandora's box.
I was about to say.
And also, it's not only just representing someone and get a fee, you need to be competent on the information you present and the market you're going to be working in. That was brought up. And although it's there, you'll see the notice that all those are going to be set aside because we're going to concentrate on sunset. So,
Madam Chair.
Oh, I should say good.
Also on page 361, number 8.3, it talks about increasing experience points in 4 out of the 5 of the last 5 years prior to applying for a broker's license, and expand the types of experience activities being counted towards the license would require rule changes. And I think if we follow Sunset Commission recommendations, I mean, that there already are a lot of requirements in place, and that to do this, I mean, we're doubling it. From 3,600 points to 7,200.
I believe if you read it all, what the broker responsibility working group came in, I can't remember if they presented this to us yet or not, but this was to allow hours to count for classroom, points to count for classroom hours. So the classroom hours could go down if you had more points. Isn't that what that was all about?
Right. They actually originally came with, they wanted to cut the hours in half from 600 to 300, but that would be legislative, and then by rule, double the experience points, because they felt experience for a broker's license is better than classroom hours.
Yeah. But that's just kind of a wish list, I think, and this is not, it's not something we're voting on. We're just looking at what they.
Right.
But page 61 forward, as you can see the note, when we met the executive committee, we discussed that this not be formally considered. And that's because Ms. Olmekson was saying that although the recommendations right now, it's not a priority. And even the Texas Realtors representative was there, did not want to commit to anything that they talked about before. So page 61 forward on recommendations are not going to be considered.
No. However, as you recall, we wanted to have all of these reports before everyone, so you had a chance to read it and spend some time on it before it actually does come before you, if it does come forward from these committees.
We're not going to be proactive.
No, it's not happening today or tomorrow or this session. Okay.
But I guess if they are going to be brought forward, who presented them?
It would be the broker responsibility working group.
Well, it'd be the commission recommendation from them.
Well, yeah. After they brought it forward to kind of, it's bubbling itself up, this stuff, from that particular committee. They're the ones discussing these things and would bring it forward to the commission.
Well, they did move it forward to the commission. The executive committee looked at it and said, while these ideas may need more vetting going forward, this is not the appropriate time to seek out any legislative changes, because we have all the sunset items that we have to concentrate on.
Thank you for clarifying that. I just knew we're not, this is just ideas right now.
Why are we looking at
Okay, did you have some things about, I'm sorry, Mr.
I was just going to say, just to remind her, I mean, we'll be, with us being up for sunset, we'll be lucky to get one out of anything on the rest of our agenda.
Right, that's right. Mr. Arriaga, did you have some questions about this stack of bills that Tony had here?
Yes, the first one, and the last one that Tony sent us emailed, Mr. Birtwells.
Yes, sir.
Who's the chair of the Sunset. And I use the word proactive because it still bugs the heck out of me on the facilities committee. What do you read from this bill, Tony? Explain what you think he's trying to say and what might happen.
I think the purpose of that bill, and I don't want to speak for Senator Birdwell, but just from the commission meetings as well, is that he just wants a process in place. He has said himself, I believe, at least a couple of times, that if the process is in place and it determines that the agency could go that route of purchasing property or building a building, he doesn't have a problem with that. He just wants to make sure that there's sufficient oversight through that process, and that's what this bill attempts to do. It addresses our agency and the agencies under 472 of the Government Code, and sets up a process for any agency that has not already allocated funds for those projects. And then it addresses secondarily agencies who have set up or allocated funds for that and what they need to do to move forward with any proposed project if it hasn't already been begun by the effective date of the bill, which is September 1st, 2019.
And that's what in essence got us in trouble, because if you look at the back of the stuff we're getting this morning, the Facilities Committee never saw this until the last meeting that we had, after the last meeting that we had. And then we had a conference call, as Commissioner Moore remembers. But something like this is being proactive. I never saw this. The Commission never saw this until way afterwards. And if I'm not mistaken, this was presented about this time, 2017, at the last legislature. Is that correct?
I don't know when. I know that was available at that time. I don't know when and where it was presented.
The information is not quite correct. So if anybody saw this, did raise an eyebrow and say, wait. They're going to give us $7.5 million, two paragraphs from the bottom, a one-time allocation. Who asked for that? Construction is going to be $27 million or more. That's embarrassing to me. But more embarrassing, I never saw this when this was addressed by the legislature last time. We do not want that to happen. And I really believe that Chairman Birdwell is saying that because if the governor's office is not going to be for it, why do we bring it up? And that's why Ms. Olmixon knows I'm still very disappointed at the staff for not making those clarifications. And that's what got us into trouble with Sunset. We need to make sure being proactive stops. And the Executive Committee talked about this, and we wanted to make a recommendation to you all about the Long Range Committee, Building Committee. We decided not to. You need to look at it first, we as commissioners, and see how we feel about that, because maybe we need a building, maybe we don't. But to me, it's important that any information that we take to the legislature, this commission has to see it, or at least the Executive Committee, and then we decide to bring it to you, which we always have.
Yes, sir.
Very disappointing, Tony.
Is there any other comments or questions anybody has on the bill list?
Yes.
Okay.
The other bills that are on here, I have not had a chance to review them. The one that's passed out this morning.
Yes, sir.
I haven't either. No one has.
I'm sorry?
No one has.
Okay. So let's discuss this tomorrow if we can.
Okay, I want to make the promise I made last session, which is this: you'll be getting an update to this list, not just at the meeting, but on a regular basis. As of this morning, I don't know what's happened in the commission meeting. I haven't checked. We still did not have our sunset bill filed yet, but obviously, as soon as that happens, you will be made aware of that. As soon as I know that's happening as well.
Thank you, Tony.
Okay. Thank you.
32. Okay, thank you, Tony. So let's go back, now that Ms. Pifo's back, and go back to agenda item 20.
This will be very short and sweet. This is an audit that was conducted that's required by the Public Funds Investment Act every 2 years. The audit is by the internal auditor and of the PFIA, And basically, we passed with flying colors, and there's nothing to report. There's no management response required. You have the report in front of you. I'd be happy to answer any questions.
So.
Thank you.
Thank you. Wait a minute. In reviewing it, I saw no recommendations and everything looked good. And I appreciate that we have a report of that nature. I would tell you that I think, and I know we're skipping around a lot, however, could you perhaps address, since you're here,
Yes.
agenda item 33, the new travel reimbursement?
What page is that?
Travel reimbursement procedures? 383.
So
It's just an agenda item. There's no papers.
There's no materials that go along with it. The recommendation that we're going to make is that when you come to the meetings, we will have at the dais a folder with your paperwork in it, and allow you then especially when you're leaving at the end of the day, to give us your paperwork at the time, and we can take it back and have, hopefully before you leave, if that's possible, a travel voucher for you to sign. If not, at least we've gotten it started, and you can bring whatever you have from the hotel, or from, if you've got travel stuff, what we already know, we will pre-populate. I've done this in other agencies where I've worked, and we found that the commissioners and board members like it a lot. So it was a proposal that we were putting forth that we would do for you for the next time at the next meeting.
Thank you. My problem is I don't do my travel. I have an assistant who does that. I just give her a bunch of papers and she figures it out. So
Then you've already got customer service there.
thank you.
You got people.
You got people.
You got people.
Can I ask a question?
Sure.
Since Amber makes our reservations typically, could she handle getting the bills through the travel agent or whoever? And I say that because the hotel does not want to give us anything in writing, in print.
No, they won't.
So if they're doing it electronically and you need to forward it to us, that's fine. But if this is going to be easier and make it easier for y'all, we thought we would give it a try. So it's just one kind of little step we can take. Absolutely, whatever works for y'all.
Let's don't do that. Let's don't jump around that much. Okay. I know you guys wanted to push hard and push through. I'm starting to think that many of the other items that we want to discuss are going to take some in-depth time to discuss them.
We said we were going to go through 23, though, right?
Well, 23, I think, is going to take incredible time.
I have a suggestion. If
Okay.
you said you had a couple speakers, does this deal with the inspector's education plan? You could open 23 and talk about that portion of it, and then table it till tomorrow morning.
Okay. Is that okay with y'all?
Since we have
Let the
people here
speakers
to...
speak, and then we can have our discussion tomorrow on that subject, so the speakers, if they want to go home, they can.
Great idea.
Okay. So I'm opening agenda item 23, and I have Mr. Harbuck. Oh, you changed your mind? Okay. Okay. Mr. Baker?
We're going to come back tomorrow and talk about this or not?
We're going to talk about it tomorrow, but if you want to talk about it today and not come tomorrow, we're offering you that opportunity.
I'd rather have the in-depth conversation tomorrow, because I've got a lot of clarification I need to do.
Awesome. Okay. Works for me. Work for y'all? Okay. I am actually think I'm going to adjourn the meeting. If that.
Do you want Mr. Warren to present the education plan?
Okay. Where is that?
Or do you not want to? You want me to do that?
You can, I'd be more than happy to answer questions, but if you want to present it.
Ties to the legislature.
Where is that?
It's under the sunset stuff.
Under what?
23?
Yeah.
Where is it at?
Part of 23.
Part of 23.
Page number.
I think it should.
I don't know yet.
Is it 23 or did we do it under legislature?
At 329.
Where did we put it?
See if it's under. I don't see the materials on it, or they.
Oh, you know what? We sent those materials subsequent.
Oh, God. Okay.
That was a supplement, right, Amber? Because we didn't have the meeting.
Oh, yeah.
Is it okay if we at least get going onto this thing so that we don't leave so much for tomorrow?
So it is.
We don't have that
in
much
your
tomorrow.
supplemental material under agenda item 23. I mean, we could do this tomorrow, but
you have Mr. Warren here to answer questions if you want him to. Otherwise, Tony and I can answer questions tomorrow because we were at the subcommittee hearing and the committee hearing. So your call, Madam Chair. If he's not signed up to present, then Tony and I can present.
Yeah, I got it.
Okay, we've only got 11, I think 11 items left to deal with tomorrow. They are going to take some, many of them are going to take some time, but I think as much as I would love to slug through till midnight, I don't think anybody will be happy at midnight. And we all plan to spend 2 days. Let's adjourn the meeting and come back in the morning at 10 o'clock.
Enough's enough, right?
So meeting adjourned at 4:20. Recessed, standing recess until 10 o'clock in the morning.
Perfect.
What?